Prayers.
Almighty God, who in your infinite wisdom and providential goodness have appointed the offices of leaders and parliaments for the welfare of society and the just government of humanity, we beseech you to look upon with the abundant favor these your servants, whom you've been pleased to call to the performance of such important trusts in this land. Let your blessing descend upon them here assembled, and grant that they may, as in your presence, treat and consider all matters that shall come under that deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the good of those whose interests you have committed to that church.
Item 2 on the order paper, communication from the chair.
Now, members, welcome you to this afternoon sitting. I just wanted to remind you that in view of the rainy season, we want to ask you to plant some trees. Last week, we launched the campaign for 40 million trees through the Ministry of Water and other agencies. So I want to urge members to visit the ministry to secure some seedlings so that you can take them home to your constituencies and make use of this rainy season. There are just a few matters of national concern. The Honorable Babadiri, 2 minutes.
Thank you, Madam Speaker. Madam Speaker, I rise on the floor to raise matter of national importance. Madam Speaker, yesterday I received shocking news from Koboko, from the mayor of our municipality, that 11 Ugandan drivers were killed along Juba-Yei Road. The 4 were killed on 28th of March, that is Sunday afternoon. And 4 of them were identified, all from Koboko. Even I have their names. The 7 were killed yesterday, 29th of March. And this was one of not identified. I know most of them are from Koboko, or even in West Nile and in Uganda. Madam Speaker, this problem of killing our people in Sudan is too much. Now we have lost these 11 drivers, and their families are now suffering. Koboko is now grieving. They went there to do business. They are taxi drivers, others are lorry drivers, and now they are no more. And then they go there to provide services to Sudanese who need the services. And for us as Ugandans, I want to say, the Sudanese are here very peacefully. We don't kill them. We are keeping them in the refugees, even they're in our communities, they are our friends. But when our people are in Sudan, they are being killed. Madam Speaker, this issue is very painful. My prayers are, 1, I would like to see that the Minister of Foreign Affairs get interest in this matter and investigate to find why are these drivers killed. Number 2, I would like the government of Uganda and Sudan to engage and talk and find a lasting solution to these everlasting killings of Ugandans in Sudan. Then Number 3, Madam Speaker, I'd like to see that the road between Juba and Yei should be protected, like the one of Juba and Nimule. The one of Nimule, at least the soldiers patrol it and the people are escorted, but the one of Juba, Yei, which is short, is not protected at all. So when you go there, you go at your own risk. So I would like to see that that road is also protected. Madam Speaker, now these 11 people have left widows, children, orphans. Now I'm requesting the government of Uganda to compensate these families to see that these children will also go to school and they get food. Madam Speaker, I want to add something small. The method, even the way they kill, they shot them in front of the passengers and they stripped them naked. And even all the passengers are stripped naked and left to go around. So that is very inhuman treatment. Madam Speaker, I'd like a lasting solution to be found between this problem of Uganda and Sudan. Thank you very much, Madam Speaker.
Aivu, Mwanabatiku.
Thank you, Right Honorable Speaker, and Honorable Babadiri for raising this very important matter. Madam Speaker, as our people also being ambushed and killed in South Sudan, just last evening, Uganda Revenue Authority enforcement agents also killed a young man who was purportedly carrying contraband goods from Congo. And it led to a fracas where the Wananchi also almost lynched URS enforcement agents. Madam Speaker, this is not the first time this kind of barbaric action is taking place in Arua and particularly West Nile. And of course, it's for obvious reasons that we neighbor DRC, and there's a lot of illicit trade that takes place. But the manner in which the URA has been enforcing or doing the enforcement has, in many occasions, left some of the culprits dead and sometimes even damaged their goods, but without any compensation. So I think it's high time, Madam Speaker, that this Parliament took some measures to put URA to order in a manner in which they enforce some of these measures to curb illicit trade. Otherwise, the URA is working for the Wananchi, and therefore they should have a human face. Because if somebody is on a bicycle and you are in a vehicle, why should you run over such a person? Instead of disabling such a person and arresting the goods. So my appeal is to Ministry of Internal Affairs to put URA to order and also bring these culprits to book so that the victims of some of these barbaric actions are compensated. I thank you, Madam Speaker.
I see the Minister for Internal Affairs here. I don't know whether he has any information about the situation of our drivers killed in South Sudan, and also the one of the URA engagement in at the border of DRC Congo, before we assign the Minister to handle.
Right Honorable Speaker, it's true that the Ugandan drivers were killed from around Friday up to Sunday. We lost about 8 to 9, The number is not yet clear because some of the people who were injured, it's possible that they could have died. This matter is known to the Ministry of Foreign Affairs because all these people died in the Sudan. Just like there was another group on the 19th who were killed on the Moyo side in the southern Sudan, about 8. They also killed, they had gone to fish. And they were killed in this area. Now, there are armed military groups in those areas who apparently are opposition forces to the government in the southern Sudan. And they are in control of that area. And therefore, the responsibility for that matter lies with the Sudanese government. The Ministry of Foreign Affairs is aware. We had a discussion with them. They are taking up the matter. Our embassy in Southern Sudan is handling it. And when they've done it so, the information, the country will be informed by the Ministry of Foreign Affairs. Regarding the operations of the URA enforcement team, it's also unfortunate that they use excessive force, and in a number of cases, they are brutal. And unfortunately, this force is not under the control of the Ministry of Internal Affairs. We regret it. It's still under government, but we will inform the Ministry of Finance, under which URA falls and under which that force falls, to make sure that they bring those people to book. Thank you.
Thank you very much, Honourable Minister. Can we ask the Minister for Foreign Affairs to respond to the prayers of the Honourable Babadiri, but also to see whether it is not necessary to issue a travel advisory to Ugandans, because these killings have taken place over like 4 days. Perhaps they should issue a travel advisory so that Ugandans know whether to go that side or not. The one concerning the URA staff, we shall ask the Ministry of Finance to come and update the country on this incident and how they are going to move forward with the management of situations such as these which happen near the Congo border. Honorable Boate Kamwa. Not yet. Honorable Masika.
Thank you, Right Honorable Speaker. I would like to raise an issue of national importance, and this is concerning our borders in Uganda. We have so many borders. I don't know the right number, but these vehicles or motorcycles have been laying idle or underutilized. People in Uganda, East Africa, and Africa, they know that a border motorcycle is just for transporting people and goods. But I've moved to many countries in China, Japan, Vietnam, and so forth. I've seen how these people can utilize their borders to boost their agricultural economy. So I feel that if we do it, we can also boost our agricultural economy, which can be multiplied 10 times, and we can get trillions from our agricultural sector. How? I saw a border, when you lift the tire behind, not even lifting, but first of all, it can be used as a plowing tool in the gardens. A boda boda has 500 horsepower, which means the power of 500 horses have been compressed in one item. And if you use it wisely, you can use a boda boda to plow the land. And the boda bodas are everywhere. This is one component. The second component, the boda boda can be used to put seeds in the soil. It can be used, if you put another one, it can be used for plowing, slashing. If you put it another component, the boda boda, if you wire the house very well, electricity wires, it can, when you come home, you can plug that component and then you will see electricity in the whole compound. And the kids can use it for, electricity for studying. A boda boda can be used to draw water and then you use it for irrigation during the dry season. If the water is very far, some pipes, plastic pipes can be connected, then a boda boda can draw this water and put it in the tanks, and then you can use it for doing the homework and even other works. If we go ahead, if I mention the works of the boda boda, it can be more than 100. So, my prayers, I request the Minister of Agriculture, if they can inform government, our government, and then the government brings in those equipments or components. A boda boda has got so many uses. You can as well, I saw in India, you can put a plastic jerrycan, a big one, like 500 grams, 500 liters. Then a boda boda can draw the human waste in the latrine and then it takes to the road where the big car is standing, which collects human dung. Then it can take it for processing for agricultural use. So in Uganda and East Africa, I've not seen anywhere apart from, I just went to Bulambuli and I saw some boys using a boda boda to draw water from the rivers and then they use it for irrigation. So I appeal to our government, most especially the Minister of Agriculture, to make sure that these items or components should be imported or made in Uganda to give to the boda boda men, not only giving but selling them at a lower price so that our agricultural sector can be boosted. Thank you very much.
Thank you very much, Honorable Masika, for your brilliant ideas. We shall ask the Minister of Agriculture to examine the possibilities of other use of the boda boda. But I wanted to ask you to work with the Committee on Science and Technology and see whether you can mount an exhibition in our next Science Week so that we can see it at work here and also help us to advocate with the government. Thank you very much. Honorable Wolf.
Thank you, Right Honorable Speaker. I am up to raise a complaint or a petition by is it Arenaitwe and Arenaitwe Sam and Adrifua Robert plus 30 others against illegal eviction and land grabbing on Block 1 of Plot 108 Kakika Cell, Kamukuzi Division, Barara Municipality, by Captain Mugume Gordon since 4th May 2002. The land dispute that started to emerge that time had an intervention of this chairperson LC3 of Kamukuzi Division, and it involved that Captain Mugume Gordon, who works in State House. And they tried to build consensus, but never succeeded. The Uganda People's Defense Forces soldier, by that time attached to PGB, Entebbe, started the process of evicting the residents. List complaints were availed to State House on 20th December 2016. Houses, household property, banana plantation were all demolished, cut, and destroyed. And they said they have been struggling there was no voice by the Office of the Director of Public Prosecution against the illegal criminal acts. And in July, a request was made as an open letter to the president. I have a copy of the letter here. I will lay on table. And an instruction was given to the resident district commissioner that time on 1st August 2016. But nothing has been done to help these 32 people. And so they reached out to my office sometime about 3 months ago. So yesterday, but last week, I handed over some copies of the document to the PPS of the president, Dr. Mona. But because the issue, they keep calling, I thought I should bring it up and ask the minister in charge for presidency through the legal department of State House should be directed by us parliament here to ensure compensation of the evictees, ensure enforcement of the judgment against the illegal eviction of Arinaitwe, Sam, Drifua, Robert, and the 30 others. But also to say that the Inspector General of Police and the Director of Public Prosecution should assist in availing a report to this House on why no prosecution and prohibition was done against illegal eviction pronounced by the court. A special land grabbing committee, if our usual committee is now failing us, should be put in place to look into this land grabbing. It is not just once. There are very many. And these people from State House usually put themselves above the law. We need to help our people better. I have this letter, open letter to the president. I will lay on the table, and also a letter to the resident district commissioner of Mbarara at that time, that is 1st August 2016. I will also lay it on the floor so that we see the greatness of this problem. 2016, 2002, 2016, and up to 2021, these people are still what? Struggling with no proper communication to them. I thank you, Right Honorable Speaker.
Honorable Leader, is the matter in court or not? Where is it?
Thank you, Right Honorable Speaker. I think the matter is right now not in court.
Okay, Honorable members, shall ask the Minister for the Presidency to examine that complaint and give us an update in a fortnight's time. Thank you. Honorable Tucker.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I raise on a matter of urgent concern about the owners of clubs. These are part of the entertainment sector that includes bars and organizers of concerts. This group of businessmen and women, Madam Speaker, are concerned that though their services are not essential, they have been diligent taxpayers and they are seeking protection from government. Madam Speaker, it's now a year since we went into lockdown, and specifically club owners, Madam Speaker, they invest between 300 to 700 Uganda million shillings to put up clubs, and sometimes even more. And such investments drive them into borrowing. So as such, before the lockdown, these proprietors had outstanding financial and contractual obligations, including loans from banks and other lenders, unpaid supplies, and rent to landlords, and contractual obligations such as lease agreements and employment. Madam Speaker, since government partially opened, the moratorium that had been put to loan payments expired. And these people are concerned that the banks are now starting to seize their property because of the loans. But also, the judiciary is already executing rent distress applications to the landlords for them to be evicted. And as such, they request the government to pronounce a moratorium on repayment of loans to commercial lenders for businesses, such that since they are still under lockdown, they avoid the rampant bank seizures that are happening. Secondly, Madam Speaker, they request halting of the evictions against their businesses by landlords, because establishing clubs takes a lot of investment, and yet when they are evicted and they remove such materials, the materials become almost useless because they can't put them anywhere. And besides, they've already established their business place. So the landlord is like taking over the business area that the club owner had already established a name about. So they don't mind still staying under lockdown because they understand the pandemic, but they request that the evictions be halted. They also request government to consider a substantial stimuli package for the sector, because they are really financially grappling, because they've taken a long time without working. They are also requesting government to defer the taxes because their businesses are still under lockdown. And they also request that government, through the judiciary, holds the execution of applications against their businesses and other businesses that are still under lockdown. Thank you, Madam Speaker.
Thank you very much, Honourable Member. I recall that in October, before we went on recess, this matter was brought to our attention, and we sent the petition to the Prime Minister as head of the National Task Force on the COVID-19, but apparently nothing has been done. Secondly, we had asked the Minister of Finance to lay here an instrument from the Bank of Uganda directing or advising the commercial banks not to foreclose on the loans and also to freeze the interest on loans, but that document has never been laid here. So we don't know whether, other than the pronouncement, whether it really happened. We still want to know. Thirdly, we think that the government should take an interest in the survival of these businesses, which are still under lockdown. So again, we want to ask the Prime Minister to come and address us on that issue. So the petition will be sent to the Minister of Finance, the Minister of Trade, and the Prime Minister for expeditious action. And in view of the urgency, we would want to get an answer within 1 week. Thank you very much. Members, now we go to item 3.
Item 3 on the order paper, laying of papers.
Can I ask Commissioner Awol to lay the papers?
Three one, reports of the Auditor General on the financial statements for the year ended 30th June 2020, 30th June 2020 for the following entities: Insurance Regulatory Authority.
Thank you, Right Honorable Speaker. I beg to lay Insurance Regulatory Authority report of 30th June 2020. I beg to lay.
Uganda Development Corporation.
I beg to lay report of Uganda Development Corporation. I beg to lay.
Insurance Training College.
Right Honorable Speaker, I beg to lay the report of the Insurance Training College.
Rural Communications Development Fund.
Right Honorable Speaker, I beg to lay the report of Rural Communication Development Fund, RCDF. I beg to lay.
The Great Lakes Trade Facilitation Project.
Right Honorable Speaker, I beg to lay the report of the Great Lakes Trade Facilitation Project. I beg to lay.
Uganda Bureau of Statistics.
Right Honorable Speaker, I beg to lay the report of Uganda Bureau of Statistics. I beg to lay.
Inspectorate of Government.
Right Honorable Speaker, I beg to lay the report of the Inspectorate of Government. I beg to lay.
Financial Intelligence Authority.
Right Honorable Speaker, I beg to lay the report of Financial Intelligence Authority. I beg to lay.
The Regional Communications Infrastructure Program, IDA loan number 5634-Uganda, UG.
Madam Speaker, I beg to lay the Regional Communications Infrastructure Program, RCIP IDA loan number 5635, Uganda. I beg to lay.
Public Procurement and its Disposal of Public Assets, PPDA Appeals Tribunal.
Right Honorable Speaker, I beg to lay the report of the Public Procurement and Disposal of Public Assets, PPDA Appeals Tribunal. I beg to lay.
Public Procurement and Disposal of Public Assets Authority.
Right Honorable Speaker, I beg to lay the report of Public Procurement and Disposal of Public Assets Authority. I beg to lay.
National Information Technology Authority, Uganda.
Right Honorable Speaker, I beg to lay a report of National Information Technology Authority, Uganda. I beg to lay.
Uganda Retirement Benefits Regulatory Authority.
Right Honorable Speaker, I beg to lay the report of Uganda Retirement Benefits Regulatory Authority. I beg to lay.
Soroti Fruits Limited.
Madam Speaker, I beg to lay the report of Soroti Fruits Limited. I beg to lay.
Uganda Investment Authority.
Right Honorable Speaker, I beg to lay the report of Uganda Investment Authority, UIA. I beg to lay.
Thank you very much, Commissioner Awol. All these reports are sent to the Public Accounts Committee, Commission Statutory Authorities and State Enterprises for perusal and report back. Can I quickly invite the Honorable Pamela Nasio? Honorable Pamela?
Thank you, Right Honorable Speaker. I raise on a matter of national importance regarding the amalgamation of the World Fund. Right Honorable Speaker, I raise on a matter of national importance to seek for an explanation from the Minister of Finance, Planning and Economic Development and the Minister of Gender, Labour and Social Development on the status of the Uganda Women Entrepreneurship Program, the WEP. Madam Speaker, whereas in the financial year 2015-2016, Government of Uganda launched the Uganda Women Entrepreneurship Program, also known as the Women Fund, to address issues of financial exclusion of women and empowerment, to improve on their income levels through provision of interest-free credit. Recognizing the tremendous success of the program across the country, in just a period of only 5 years of implementation, with an impressive recovery of 82%, according to the program annual report and other reports, including the report of the NRM Manifesto Implementation Unit, which noted excellent performance of the program. For example, out of 23 billion amount due, 19.9 billion has already been recovered under the program. Recognizing that WEP is anchored within national, regional, and international commitments and obligations on economic empowerment of women,
Right Honorable Speaker and Honorable Members, Rule 172 of the Rules of Procedure of Parliament mandates the Committee on Rules, Privileges and Discipline by order of the House to review the rules of procedure of Parliament from time to time and to make such recommendations to the House for amendments as the committee considers necessary for the satisfactory functioning and efficient transaction of the business of the House and its committees. Pursuant to Rule 172, Sub-Rule 1C, the Speaker on the 28th January 2021 directed the committee to review the rules and report back to the House. The committee executed the task and hereby presents its report to the House for consideration. Methodology. The committee perused the rules of procedure and identified.
Thank you very much, Madam Speaker. The chairperson has cited the rule 172(1)(c). According to this rule, the review will be done by order of the House. My understanding of the order of the House is that there will be motion and Parliament will vote on it to order. The chairperson says on the directive of the Speaker. The procedure issue I am raising is whether the chairperson can go ahead to conduct work not ordered by the House as the rule provides, but as instructed by the Speaker. That's the procedure issue I am raising.
Honourable members, the Speaker is the custodian of rules of this House. And over time, we have identified areas that need to be amended. That's why we asked the committee to go and make some proposals. So the proposals have come to this House. You will study them, discuss them, and they will be amended according to what will be the outcome of the House. Proceed with the report, Honourable Chair.
Thank you very much, Right Honorable Speaker, for your wise ruling. The committee reviewed a report from the technical committee.
Other procedure. Maybe, Madam Speaker, I didn't put my question right. The question I'm raising is a question of law. Whether the Speaker, in this case, becomes the House. And that's the guidance I am seeking from you. Because the subject matter is a very serious matter concerning this Parliament. And therefore, we need to follow our rules as they are written. Otherwise, to disregard the rules as they are and you bring more, for me, doesn't make sense. So the procedure issue I'm raising, Madam Speaker, is for you to interpret whether the Speaker has become the House. And therefore, we are now working not on the order of the House, but on the directive of the Speaker.
Honourable Member, proceed. Yes, Honourable Tieno.
The committee 3 considered some specific directives from the House and incorporated the recommendations in the report. 4, received submissions from some members of Parliament, and 5, compiled this report that it now presents to this House for consideration. 2.0, observations and recommendations. 2.1, administration of oath Rule 3 provides for the clerk to Parliament to administer the oath of allegiance and the oath of a member of Parliament to new members of Parliament prior to the first sitting of Parliament. In subsequent cases, after constitution of the House, this rule requires the clerk to administer the oath before the House. In the recent past, however, situations have arisen where the oath had to be urgently administered during periods when a duly constituted Parliament was on recess. Such circumstances necessitated the oath to be administered before the Speaker in places within the precincts of Parliament other than the House. The committee proposes that the rules should be amended to provide for the administration of the oath before the Speaker during periods when Parliament is on recess or in situations where a member-elect is unable to reach the parliamentary buildings for reasons beyond his or her control. 2. Election of Speaker and Deputy Speaker. The committee on the 10th March 2021 received a directive from the House to make proposals on how to curb the use of foul language against different contenders for the positions of Speaker and Deputy Speaker in the 11th Parliament. The committee, in its consideration of the matter, found that the positions of Speaker and Deputy Speaker are held in such high esteem that the candidates must not be seen in situations that could compromise their dignity. It therefore follows that public campaigns should not be permitted because there are high chances of hurting the dignity of the individuals concerned and in turn the institution of Parliament. It therefore recommends that Rule 5 should be amended to bar candidates from the said positions from public campaigns. 3. Resignation of a Speaker or Deputy Speaker. The rules of procedure currently provide for the election of Speaker and Deputy Speaker of Parliament, but the only exit from these positions envisaged is by impeachment under Rule 107. It was observed that the rules do not provide for voluntary exit from these offices. The committee notes that this gap needs to be rectified and therefore proposes that the rule should be amended to provide for resignation from the offices of Speaker and Deputy Speaker. 2.4. Sittings of the House. The size of Parliament has increased over time, with the 11th Parliament expected to be 72 members, bigger than the 10th Parliament. It's, however, a matter of concern that the hours of sitting of Parliament have remained the same. With a view to creating more opportunities for members to speak in the House, the committee proposes that Mondays should be made sitting days in addition to Tuesday, Wednesday, and Thursdays. The committee therefore proposes that Rule 19, Sub-Rule 2 should be amended to include Monday as a parliamentary sitting day. 2.5. Statement of business by the leader of government business. Rule 28 requires the leader of government business on every last sitting day of the week to make a statement in the House regarding the government business of the succeeding week. The committee observes that the rule is currently inactive, and this limits the participation of members of Parliament in debates of the House because they are not given opportunity to sufficiently prepare for parliamentary sittings. The committee proposes that the rules should be amended to make it mandatory for the clerk to ensure that Rule 28 is reflected on the order paper of every last sitting day of the week. 2.6. Parliamentary calendar. The Speaker, at the beginning of the second session of the 10th Parliament, announced a parliamentary calendar that gave priority to different categories of business during each meeting of the session as follows. First meeting prioritization of bills. Second meeting, prioritization of committee reports. And third meeting, prioritization of the budget process. The committee welcomed the calendar, but in addition to the current arrangement, it proposes that exclusive periods should be allocated to committee activities, plenary sittings, and recess within a given meeting in a session. The proposed amendment will enable members to concentrate on one aspect of parliamentary business at a given time. This is likely to improve the efficiency of Parliament, with members being more available and prepared for most parliamentary business, and at the same time, more accountable to their constituents. It therefore proposes that Rule 25 be amended as such. 2.7, Prime Minister's time. Prime Minister's time provided for under Rule 41 was borrowed from the House of Commons in the United Kingdom. However, the committee notes that the Prime Minister in Uganda does not have the same powers as the Prime Minister in the United Kingdom. In the United Kingdom, the Prime Minister is the head of government and chief executive of the country. Therefore, he is fully answerable for the actions of his government, whereas in Uganda, this is not the case. In Uganda, the Prime Minister is answerable to the President, who is both the head of state and head of government as per Article 98(1) of the Constitution of the Republic of Uganda. The committee observes that under the current arrangements, answers during Prime Minister's question time may not be conclusive because on certain issues, the Prime Minister may have to consult with the President and the sector ministers. This makes the procedure not as effective as it is in the United Kingdom. The committee therefore proposes that questions be asked during questions to be asked during the Prime Minister's time should be 1, submitted to the Prime Minister in advance. 2, limited to questions on government policy. 3, clustered together if they are related to the same policy. A summary of questions asked during Prime Minister's time should be published periodically and distributed to members, detailing a categorization of questions asked under each policy and the list of members who asked the questions. 2.8, reorganization of Part 9 of the rules relating to questions. Part 1X of the rules that govern the various types of questions in the House is devoid of a chronological flow, yet chronology is a cardinal tenet of rules. This has partly inhibited the utilization of some procedural avenues for questions, such as questions for oral answer and questions to commissioners and chairpersons. It's against this background that a reorganization of the relevant rules, notably 42 to Rule 50, has been proposed. 2.9, consideration of annual reports of government agencies and public corporations. Parliament periodically receives annual reports of various public entities, and in some cases, especially reports of parastatals. They are referred to Public Accounts Committee, commissions, statutory authorities, and state enterprises, or PAC COSESE. It was noted that these annual reports usually deal with the functions and operations of these public entities, an aspect that would be best suited for sectoral committees. The consideration of annual reports should therefore be left to sectoral committees, since they spell out the operations of an entity in a given year and its inherent oversight function. 2.10, need for policy statements to conform to Section 43 of the Access to Information Act. The Access to Information Act 2005 requires that policy statements should include a listing of requests for access to information made by the public during the previous year, indicating whether or not access was granted and the reasons for denial. the committee proposes that Rule 145 be amended to conform to the requirement of the Access to Information Act 2005. 2.11, consideration of supplementary estimates. The rules only provide for consideration of supplementary estimates on the floor of the House under Rule 152. The committee observes that this is an omission because the procedure for considering supplementary estimates should be the same as the one for considering the annual budget. It should therefore be laid on the table, then referred to the Budget Committee and the relevant sectoral committees. The current practice is to have the Budget Committee consider the supplementary estimates. However, this committee notes a gap in this procedure because the sectoral committees that oversee the sector that benefited or is to benefit from the supplementary request has a better understanding of the financial requirements of the sector and is the one involved in scrutinizing all other aspects of the sector budget. The committee further notes that supplementary requests presented to the House must clearly state the source of funding to enable Parliament act appropriately as the case may be. For example, in the event that the source of funding is external financing, then the House should consider the loan request before supplying the supplementary budget request. The committee therefore proposes that rules be amended to clearly provide the procedure for considering a supplementary budget request. 2.12, membership to committees. Rule 154 inter alia provides that with the exception of the Business Committee, Appointments Committee, and Budget Committee, a member shall not belong to more than 2 committees. This committee observes that in order to cater for the ramifications of the increasing number of members of Parliament, such as space constraints and exceedingly large numbers of members of Parliament on each committee, if the status quo remains the same, membership to committees should be limited to 1 committee per member, with the exception of the Business Committee and the Budget Committee. The membership to each committee should be on annual rotational basis. The committee further argues that limiting members to belong to only 1 committee would also improve on the efficiency and effectiveness of committees, as the problem of conflicting schedules would be eliminated, hence ensuring quorum. Members would also be able to concentrate on their committee activities. 2.13, the Committee on National Economy. Rule 175 mandates the Committee on National Economy inter alia to examine and make recommendations to the House on all loan agreements required to be authorized or approved by the House under Article 159 of the Constitution. This committee observes that the loan requests are for projects that fall within sectors under the purview of sectoral committees. It therefore follows that sectoral committees have a better understanding of issues within the sectors that they supervise. The current situation is that the Committee on National Economy scrutinizes the loans without an input from the sectoral committees. This could result in ill-informed decisions. The risk is heightened by the fact that the rules do not provide for a checklist of documents that must accompany all loan requests submitted to Parliament for approval. The committee also noted that the Committee on National Economy does not consider loan agreements, but rather the terms and conditions of the loan requested for. This is so because there is no agreement at the point when the committee is scrutinizing the loan request. The committee recommends that the rules should be amended. 1, to provide for the Committee on National Economy to receive an input from the sectoral committees that oversee the sectors that are to benefit from a particular loan. 2, provide for a checklist of documents that must accompany all loan requests submitted to Parliament for approval. And 3, reflect the fact that the Committee on National Economy does not consider loan agreements, but rather the terms and conditions of the loan requested for. 2.14, functions of the Committee on Government Assurances and Implementation. One of the functions of the Committee on Government Assurances and Implementation stipulated under Rule 176 is to submit to each sectoral committee a list of government assurances that are pending fulfillment during consideration of policy statements and budget estimates. The committee, however, observes that sector allocations are made during considerations of the budget framework paper, a process that precedes consideration of the ministerial policy statements. By the time the committee is considering policy statements, it is too late to introduce new items in the budget. The committee therefore proposes that the rules should be amended to have the Committee on Government Assurances and Implementation submit the list of government assurances to the relevant committees during consideration of the budget framework paper. 2.15, functions of the Committee on Human Immunodeficiency Virus or Acquired Immunodeficiency Syndrome, HIV/AIDS. Rule 181 only envisages Parliament or the committee working closely with the Uganda AIDS Commission. However, the committee notes that the Committee on HIV/AIDS in its activities has to relate closely with the Ministry of Health as the responsible center for public health care service delivery. The committee therefore proposes that the rules should be amended to include the Ministry of Health as an entity that the Committee on HIV/AIDS must liaise with in the fight against HIV/AIDS. 2.16, workload of public accounts committees. Pursuant to Article 163 and in accordance with Article 90 of the Constitution of the Republic of Uganda, financial accountability committees are mandated to consider the Auditor General's reports in their respective jurisdictions with a view to enabling Parliament debate and take appropriate action thereto. The committees are Public Accounts Committee, Central Government, Park Central Public Accounts Committee, Local Government, and Public Accounts Committee, Commissions, Statutory Authorities, and State Enterprises. The committees are currently overwhelmed by the amount of work before them, and as a result, there is a substantial amount of backlog. In the case of Park Kosase, for example, its mandate covers 121 entities, out of which only 20 have been considered in the course of the 10th Parliament. The committee received a submission from a team of members of Parliament proposing a split of the accountability committees to enable efficiency. It, however, considered the proposal and concluded that the split of the committees will not result in efficiency if the same method of work is maintained. The committee noted that most Commonwealth parliaments have only one public accounts committee and they seem to work efficiently. The committee proposes that a more detailed study of the methods of work of public accounts committees be undertaken so as to find a more sustainable method that will ensure efficiency. 2.17, fast-tracking implementation of parliamentary resolutions. The committee received a directive from the Speaker to examine the rules of procedure for mechanisms to ensure compliance by the executive with resolutions of Parliament. This followed the receipt of a letter from Honorable Alex Ndezi, MP for PWD, proposing amendments to the rules to include provisions that will ensure fast-tracking the implementation of the parliamentary resolutions. The Committee on Examining the Rules found that Rule 217 sufficiently serves the purpose. It provides that a minister shall submit to Parliament an action taken report detailing what actions have been taken by the relevant ministry following the resolutions or recommendations of Parliament or committee. 2.18, Special powers of committees. Rule 205E gives parliamentary committees powers to confine for any specific periods any recalcitrant witnesses and cite any person for contempt. This committee, however, observes that this provision should be limited to confining the person for further investigation to avoid abuse. The committee recommends that the rules should be amended to provide the boundary of this rule. 2.19, issue and service of summons. Rule 211 provides that an order to attend or to produce documents before a committee shall be notified by a summons signed by the chairperson of the committee. This provision contradicts Section 9 of Parliament Powers and Privileges Act, Cap 258, that provides for the clerk to Parliament to sign the summons under the direction of the Speaker. The committee proposes that the rules be amended to conform to the Act. 2.20, regularization of receipt of documents in committees. The irregular practice of chairpersons, members, and some unauthorized staff receiving documents on behalf of committees has been noted. This is in contravention to Rule 212 that stipulates that no document received by the clerk of a committee shall be withdrawn or altered without the knowledge and approval of the committee. The breach of this rule often imposes undue influences on committee decisions and potentially breeds mistrust in committees and may pose the risk of adulterating committee outputs. The committee proposes an amendment to Rule 212 to emphasize the need for all official documents submitted to committees to be through the clerk to the committee. 2.21, rules of procedure for the election of members of the East African Legislative Assembly. Under Appendix B, 1, signatures supporting nominations. The rules provide that all nomination forms shall include signatures and constituencies of not less than 20 members of Parliament supporting the nomination of the candidate, and that a member of Parliament shall not nominate more than 9 candidates for election to the Assembly. The committee observes that A, the number of 20 members of Parliament required to nominate a candidate for election to the EALA is not commensurate to the number of the electorate. It also unnecessarily strains the candidates. B, there should be a penalty for a member who nominates more than 9 candidates. C, a candidate who is nominated by a member who nominates more than 9 candidates should not be punished for the action of the errant member. The committee proposes that A, the number of signatures required to support the nominations should be reduced to 5. B, where it is found that a member has nominated more than 9 candidates, the member shall be cited for contempt of Parliament and referred to the Committee on Rules, Privileges, and Discipline. C, the 10th and subsequent candidates nominated by a member who nominates more than 9 candidates shall have the nomination by that particular member nullified and be given 3 working days to get another member of Parliament to nominate them. 2, nomination fees. The committee proposes that in order to harmonize the election procedures of the East African Legislative Assembly with that of other electoral offices in the country, a nomination fee should be introduced. The committee proposes that the rules be amended to provide for a nomination fee of Uganda shillings 3 million for candidates for election to EALA. 2.22, electronic media coverage of the House. The advent and proliferation of social media applications in media coverage and information flow has presented both opportunities and challenges. While it has eased information flow, It has also stretched the right to privacy and heightened misinformation. It's against this background that the committee observes that electronic coverage of House proceedings must be further regulated. The committee proposes that Appendix G of the rules should be amended to further regulate electronic coverage of House proceedings. 3.0. Conclusion. Madam Speaker, honorable members, I beg to move that this report be adopted by this House. Thank you.
Thank you very much, Honorable Chair and members of the Rules Committee. Now, members have proposed that you now go and study the proposals, and if there are any who wish to make proposals, they should be submitted early enough to the clerk. Otherwise, there will be no spontaneous proposals from the floor. A date will be given for the debate of this report. Thank you.
Item 5 on the order paper, Bills Committee stage. The Succession Amendment Bill 2018. Clause 27. Clause 27.
Honourable members, we had partially considered the amendments to this law. We had gone as far as clause 27. Honourable Chair.
Yes, Chair, in clause 27, we have replacement of section 86 of the Principal Act. In the proposed amendment, to section 86, replace the proposed section 2 with the following. 2, words in a will expressive of relationship shall be taken to include A person who is related to the deceased by the full blood or half blood. B, a person born during the deceased's lifetime, and those who received in the womb on the date of the deceased person's death and subsequent born alive. C, male and female relatives of the deceased person. Justification, this is for clarity, better drafting, and completeness.
You have heard the proposals under Rule 27. I put the question that clause 27 be amended as proposed. Those in favor say aye, the contrary no. Let's have it.
7 as amended.
Put the question that clause 27 as amended do stand part of the bill. Those in favor say aye, the contrary no. Let's have it.
Clause 28.
Put the question that clause 28 do stand part of the bill. Those in favor say aye, the contrary no. Let's have it.
Clause 29.
Clause 29, Honorable Chair.
Clause 29, replacement of section 179 of the Principal Act. The proposed section 179 is amended as follows. A, in the proposed section, subsection 1, insert the figure 36 6 immediately after figure 29. B, in the proposed section 3, insert after the word may the following: within 6 months of the recovery of the donor. Justification: to subject the provision to section 36(6), which exempts residential holding, including chattels, from being given away in contemplation of death. To impose a timeline within which a donor may redeem the property he or she has granted to a person in contemplation of death.
Now, members, you've heard the proposal to clause 29. I put the question. Clause 29 be amended as proposed. Those in favor say aye. The contrary, no.
Chair, we are also inserting a new clause immediately after clause 29 of the bill.
Let me first put the question to the. I put the question that clause 29 as amended do stand part of the bill. Those in favor say aye. The contrary, no. Ayes have it.
Clause 29 as amended.
We have already put that. Let's go to the new clause. The new clause, Honorable Chair.
Yes, inserting a new clause immediately after clause 29 of the bill. Immediately after clause 29, insert the following new clauses. Amendment of section 183 of the Principal Act. Section 183 of the Principal Act is amended by numbering the existing provision as subsection 1 and inserting immediately after subsection 1 the following. 2, where a testator is survived only by a child and does not expressly appoint an executor, but appoints a guardian for the child, the guardian so appointed shall be the executor of the will of the deceased person.
Now, members, the proposal that a new clause be introduced as proposed. I now put the question that a new clause be introduced. Those in favor say aye. The contrary, no. Ayes have it.
Is also amendment of section 184 of the Principal Act. Section 184 of the Principal Act is amended by A, numbering the existing provision as subsection 1. B, substituting for the word is of unsound mind appearing in the provision, the words who has mental illness. And inserting immediately after subsection 1 the following. 2, notwithstanding anything in this act, court shall have the discretion to determine whether a person who is otherwise qualified to be granted probate is fit and proper, and court may defer the appointment of the executor or the executrix to a later date or refuse to grant probate where an applicant is not suitable.
Honourable members, but I think you should avoid numbering the subsections. I wish you could leave that to the drafts people. But I put the question that section 184 be amended as proposed. Those in favor say aye. The contrary, no. It's a bit.
Chair, we also amendment of section 189 of the Principal Act. Section 189 of the Principal Act is amended by A, numbering the existing provision as subsection 1. By B, by inserting immediately after subsection 1 the following new sections. An executor or executrix who, before the grant of probate, misapplies the estate of the deceased person or subjects it to loss or damage is guilty of an offense and is on conviction liable to imprisonment for a term of 2 years or to a fine not exceeding 48 currency points or both. In addition to the penalty in subsection 2, the person convicted shall be liable to make good to the estate and beneficiaries of the estate the loss or damage so occasioned.
Honorable Chair, I think you all these under closed, the same clause said, 29.
Yes.
I think you did them all first because they're all under the same clause.
Amendment of section 190 of the Principal Act. Section 190 of the Principal Act is amended by A, numbering the existing provision as subsection 1 and substituting the words is of unsound mind appearing in the provision of the words who has mental illness, and B, inserting immediately after section 1 the following: notwithstanding anything in this act, court shall have the discretion to determine whether a person who is otherwise qualified to administer an estate under this act is fit and proper to do so, and the court may defer the appointment of an administrator to a later date or refuse to grant letters of administration where an applicant is not suitable. Amendment of Section 192 of the Principal Act. Section 192 of the Principal Act is amended by numbering the existing provision as subsection 1 and inserting immediately after subsection 1 the following new subsection. An administrator who, before the grant of letter of administration, misapplies the estate of the deceased or subjects it to loss or damage shall be guilty of an offense and shall, on conviction, be liable to imprisonment for a term of 2 years or to a fine not exceeding 48 currency points or both. In addition to the penalty in subsection 2, the person convicted shall be liable to make good to the estate, the beneficiaries of the estate, loss or damage so occasioned. Amendment of Section 200 of the Principal Act. Should I go on that too, Chair?
No, not yet. Now, Honorable, you need to correct the spelling of defer under Section 190. The new subsection, it should be D-E-F-E-R, not D-I-F-F-E-R.
Noted, Chair.
Okay, members, put the question that clause 29 is amended variously as proposed. Those in favor say aye, the contrary no. I submit.
I just wish to make a small correction. I just wish to make a small correction, Madam Speaker.
Yes.
On the amendment of Section 192 of the Principal Act, on clause 2 or subsection 2, they are saying an administrator who before the grant of letters of administration, it should be a person who before the grant of letters of administration misapplies the estate of the deceased. My request is we replace the word an administrator, the word is an administrator, with the word a person, because he's not yet an administrator at the time he misapplies the estate, because he's not yet granted letters of administration. I beg to move.
Honorable Chair, I believe you don't have an objection.
Chair, I thank the Land Attorney General for that insight, and we do concede. Chair, maybe it's still under clause 29. We have another amendment, which is, if I may read it, amendment of Section 200 of the Principal Act. Section 200 of the Principal Act is amended by substituting for the next of kin the words the spouse and the lineal descendants of the deceased person. Justification. The amendment proposed to Section 183 is in recognition of the current position of the law as far as the appointment of guardians and execution of estates of children is concerned. In Section 184 and 190, for consistency, to change the nomenclature used for the unsound mind, which condition may not be ascertainable to mental illness, a condition that is ascertainable under laws of mental illness. The term next of kin was not defined in the Principal Act and is therefore impossible to determine, considering that there is no provision requiring the appointment of the next of kin. Therefore, for consistency, the term needs to be replaced with words which is used ordinarily in the case given the centrality of the spouse and the lineal descendants in the grant of letters of administration, then it is imperative that the notification required in this section is given to the person proposed in the bill. To impose a fit and proper person test in the appointment of administrators and executors. It also incorporates the proposal made in the 2019 Succession Amendment Bill, particularly clause 24, 25, 26, 27, and 29. Thank you, Chair.
Now, Honorable Chair, apparently we finished the clause 29. These are now new proposals, isn't it? They are new proposals. Okay. Okay, now members, put the question that new clause to be introduced as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 30.
Clause 30, Honorable Chair.
Chair, clause 30 is insertion of a new section 201A to the Principal Act. In clause 30, the proposed section 201A is redrafted as follows. 201A, preference of surviving spouse to administer the estate of the deceased person. 1. The surviving spouse shall have preference over any other person in the administration of the estate of the deceased intestate. 2. The preference of the surviving spouse under subsection 1 may be disregarded by the Administrator General where A. The surviving spouse is not a fit and proper person to administer the estate of the deceased spouse, or B. The Administrator General finds it necessary in the circumstances of the estate to grant the administration of the estate to another person. Justification: to codify a practice developed by court to wherein widows and widowers are no longer given priority over the administration of estates of their deceased partners due to the reality of our complex family structures. Judges are uncomfortable with such application where a deceased person is survived by children from different women or in a polygamous family, since court is not sure of the number of partners or children the deceased had at the time of death. In order to protect the interests of all the beneficiaries of such estate, there are instances where it may be preferred that the administration is granted not to the surviving spouse alone, but to any other person alone or a group of people with or without the surviving spouse. Next is the proposal to give preference and not priority to the surviving spouse is to protect other beneficiaries of the estate, especially in polygamous relationship, where spouses have obtained administration without the knowledge of their stepchildren and have disinherited them. It is for this reason that the courts themselves are reluctant to issue grants to widows applying alone, unless there is proof that all the children are born of the widow and the deceased.
Now, honorable members, I think when we were doing another bill, there were issues around this provision. Did we accept it in the Administrator General's Act? I do recall that we had issues about this type of arrangement when we were doing the Administrator General's Act. I want to know whether we passed it when we were doing the Administrator General's Act.
Madam Speaker, this matter was removed from the Administrator General's Act and placed in this one.
Oh.
Yes.
I see. Okay. Okay, now members, put the question that clause 30 be amended as proposed. Those in favor say aye, the contrary no.
Clause 30 as amended.
Questions that clause 30 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 31.
Put the question that clause 31 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 32.
Clause 32. Put the question that clause 32 be deleted. Those in favor say aye, the contrary no. Ayes have it.
Clause 33.
With the question that clause 33 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 34.
With the question that clause 34 be deleted. Those in favor say aye, the contrary no. Ayes have it.
Clause 35.
Honorable Chair, clause 35.
Clause 35, replacement of section 215 of the Principal Act. In clause 35, redraft the proposed section 215 as follows. 215, administration when child is sole beneficiary or residuary legatee. 1, where a child is the sole beneficiary or sole residuary legatee, letters of administration with the will annexed may be granted to the guardian of the child or to such a person as court determines fit until the child attains the age of majority. Not 2, notwithstanding subsection 1, where the sole beneficiary or sole residuary legatee is 18 years and above, court may, on the application of the sole beneficiary or sole residue legatee, A, grant the sole beneficiary or sole residue legatee letters of administration or probate where court considers the sole beneficiary or the sole residue legatee a fit and proper person, or B, grant the sole beneficiary or sole residue legatee letters of administration or probate under the supervision of court or the administrator general where applicant is not a fit and proper person. Justification. Currently, section 215 conflicts with section 184 of the Succession Act insofar as allowing the appointment of a minor as executor. The amendment is therefore to ensure section 215 is in conformity with section 184. The other justification is to remove the ambiguity in the amendment proposed in the 2018 bill in so far as it allows the appointment of the guardian of the child as the administrator of the estate when the child is the sole executor. As noted, the child cannot be appointed executor as required in section 184, and also it assumes that the guardian of the child will be appointed to administer the estate on behalf of the child, yet court may appoint any other person in spite of the presence of the guardian. The other justification is to expand the provision to allow for the supervised administration of the estate where a young person is appointed administrator. This will safeguard the estate from abuse. And finally, to limit the provision to a situation where there's a sole beneficiary or residuary legatee. Chair, there is also a clause to be, I don't know whether I should read the other insertion.
Let's deal with 35 first. Now, members, with the question that clause 35 be amended as proposed, those in favor say aye, the contrary no. Ayes have it.
Clause 35 as amended.
Question is that clause 35 as amended do stand part of the bill. Those in favor say aye, the contrary no. New clause. Honorable Chair.
Yes, Chair, the new clause is immediately after clause 35 of the bill. Immediately after clause 35, insert the following new clause: repeal of section 216 of the Principal Act. Section 216 of the Principal Act is repeal justification, consequential amendment arising from the amendment of section 215 as proposed in clause 35. The other one is to incorporate proposals made by the 2019 Succession Amendment Bill, especially in clause 31. And finally, for consistency, to remove matters that conflict with section 184, wherein the appointment of minors as executors is specifically barred. Good, Chair.
Now, members, with the question that a new clause be inserted as proposed, those in favor say aye, the contrary no. Ayes have it.
Clause 36.
36, Honorable Chair.
Amendment of section 234 of the Principal Act. In clause 36, replace the proposed amendment of section 234 with the following. Section 234 of the Principal Act is amended, A, in subsection 2 by inserting immediately after paragraph E of the following. F, the person to whom the grant was made has grossly mismanaged the estate. B, by inserting immediately after subsection 2 of the following. Where grant of probate or letters of administration is revoked under subsection 2B or F of this section, the executor, executrix, or person to whom letters of administration were granted, as the case may be, shall be guilty of an offense and shall, on conviction, be liable to imprisonment for a term of 3 years or to a fine not exceeding 72 currency points or both. 4, in addition to the penalty in subsection 3, the person convicted in section 3 shall be liable to make good to the estate, the beneficiary of the estate, the loss or the damage so occasioned. 5, court may, in the same process for revocation of letters of administration, grant letters of administration to another to grant where court determines that such a person is a fit and proper person to be granted letters of administration under this act. Justification: to create criminal offense against person who obtained letters of administration through fraud and untrue allegation as prescribed in section 234, 2B and F. Imposing such an offense against a person who fails to file an inventory would scare would-be administrators or executors and make the administration of estate hard. Criminal sanctions should be left for serious offenses related to wastage, theft, conversion, deliberate misapplication of estate property, or forgery of documents during or before the process of administration of the estate. The other justification is to adopt proposals made by government in clause 32 of the Succession Amendment Bill 2019, wherein government proposes to impose criminal sanction against the executor, executrix, or person granted letters of administration where letter or probate are revoked by court. And finally, to save time and resources, to empower court to grant letters of administration in the same process as the process of cancellations of letter of administration. Chair, there are other insertions.
This anyone? Yes, Honorable Nanda. Let's first deal with the existing clause.
Madam Chair, the chair is saying of the committee that grossly mismanaged. Yet here in the bill it says has mismanaged. Mismanagement. Why are you bringing the word gross and not adopting what is in the bill?
Honorable Nandala, what is your issue?
According to the report, it was saying as Morris had adopted the committee, but when the chair got up, he says the person to whom the grant has grossly mismanaged. Now, my issue is, in the bill it was saying the person to whom the grant was made has mismanaged. Now the issue, how do you measure gross and mismanaged? Because mismanagement is mismanagement. You can't look for gross of the estate.
Chair, the impression initially was that that section 36 had been amended and therefore, but and that's why the gross was put in. But I think there's a consensus that we could, if there's an issue, we can leave it out.
Yes, because if you say gross, it means if it's not gross, it is acceptable. That's what
we concede, Chair.
Okay. So we leave section 234 as it was. That's in relation to the first subclause. What about the rest? The rest okay? Okay, honourable members, I put the question. Put the question that clause 36 be amended as proposed in subclause B, 3, 4, and 5. Those in favor say aye, the contrary no. Ayes have it.
That's clause 36 as amended.
I put the question that clause 36 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it. New clause.
Chair, we are actually inserting a new clause immediately after clause 36. And inserting the new clause immediately after clause 36 as follows. Amendment of section 235 of the Principal Act. Section 235 of the Principal Act is amended by repealing subsection 2, and then amendment of the section 236 of the Principal Act. Section 236 of the Principal Act is amended by replacing the term district delegate with chief magistrate and a magistrate. Justification: this is a consequential amendment arising from the deletion of the word delegate, which makes the provision redundant. Secondly, to adopt amendments proposed in clause 33 and 34 of the 2019 bill. Thank you, Chair.
Members have put the question that a new clause be introduced as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 37.
Put the question. Clause
37.
I put the question that clause 37 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 38.
38, Honorable Chair.
Clause 38, amendment of section 258 of the Principal Act. In clause 38, in the proposed amendment to section 258, substitute for the proposed subsection 2 and 3 of the following. 2, a person to whom probate is granted under subsection 1 shall carry out the duties and function authorized by the grant of probate for a period not exceeding 2 years. 3, notwithstanding subsection 2, court may, on application, extend the duration and prescribe in the duration prescribed in subsection 2 for a further period of 2 years if it is satisfied that A, in the best interest of the beneficiary to extend the period, and B, the person to whom the grant of probate was made as 1, Roman numeral 1, complied with the provision of this act or any other condition on which probate was granted. 2, obtain the consent of all the beneficiaries in the estate for which the probate was made. Subsection 4 is subsection 2, 3 shall not apply to A, probate granted to a guardian under section 215, except that for cases falling under subsection 215, probate shall terminate automatically as required in section 215 of this act, or B, probate granted to the Administrator General under the Administrators General's Act. Justification: the imposition of a validity timeline will result in additional costs on the estate to renew probate, which will expose the estate to additional costs, thereby eroding the beneficiary's legacy. Next is to limit the functions of the executors to 2 years, since in majority of estates, the function of executor being the collection and distribution of the estate to the person entitled to it can be carried out within 2 years, and any attempt at increasing it beyond that time will delay the beneficiaries from accessing their entitlements and will result in the executor unreasonably holding onto the estate for personal gain. limiting the grant to 2 years would put the executor on notice that their role is much limited and they would execute their duties as soon as possible. Providing a total term of 6 years as proposed in the bill would be counterproductive when what is needed is for administration to be concluded as fast as possible. The provision also did not take into account estates of minor children as prescribed in section 215, wherein the office of the executor does not terminate until the child, who is the sole legatee or residual legatee, has reached the age of majority. In order to reduce on the cost of the administration of estate, the Administrator General need not give consent to applications made under subsection 3. To impose grounds upon which court may extend the duration of grant, to limit the application of the provision to guardians since they are looking after the interests of the children, and finally to prescribe the duration of the extension.
Yes, Honorable Nanda.
Madam Chair, the clarification I want to get, first of all, in the justification, the chairman of the committee is saying 2 years. Yet in the bill, he's saying it should not be beyond exceeding 3 years. I want us to, first of all, harmonize that, and that's where I'm coming from. And Madam Chair, in the bill it says the grant of probate under subsection 1 shall be valid for a period of 3 years from the date of issue. Now, what is the change? First to say not exceeding 3, and this one which is in the bill, because I want to understand what he's trying to cure. And the second one, why is it in the justification is talking about 2 years, and yet here it is talking about 3 years. And me, in my view, I would go with the justification and say the grant of probate under subsection shall not be valid, shall not exceed 2 years. Because the moment it exceeds 2 years, the executor will be there just wanting to eat the estate. If we discover the estate is juicy, is what, and at the end, the beneficiaries will be at the loss. Such executor should execute their period within 24 months, they should be done. So it shouldn't be beyond 2 years, as we have done in the justification, but not which you are saying in the bill.
Honorable Chair.
Madam Speaker, one, our intention is to align this with what we have in the Administrator General's Act, where we also reduced it to 2 years. We capped it at 2 years. Secondly, I believe my senior colleague Nadala does not have what we are presenting. He has the bill, but what we are presenting is a proposed amendment to the bill. I beg to submit.
Members?
Madam Chair, I want to tell my younger brother that in the proposed amendment, the committee is saying not exceeding 3 years. Eh?
2 years.
So this report has a mistake. No, this report has signatures. Okay?
You know, the report I have says 2 years.
Yes, 3 years.
Two. Honourable members, I put the question that clause 39 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it. Put the question that clause 39 as amended do stand part of the bill. 38?
Yes.
We finished 38.
It was clause 38.
39, we have an amendment in clause 39.
I'm also reading the document.
Page 49.
Into page 50. Okay, put the question that clause 38 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 38 as amended.
Question is that clause 38 as amended do stand part of the bills. Those in favor say aye, the contrary no. Ayes have it.
Clause 39.
39, Honorable Chair.
Clause 39, amendment of section 259 of the Principal Act. In clause 39, substitute for the proposed amendment to section 259 with the following. A person to whom letters of administration are granted under subsection 1 shall carry out the duties and function authorized by the letters of administration for a period not exceeding 2 years. 3. Notwithstanding subsection 2, the court may, on application, extend the duration prescribed in subsection 2 for a further period of 2 years if it is satisfied that A, it is in the best interest of the beneficiary to extend the period, and B, the person to letters of administration were granted, as A, Roman numeral 1, complied with the provision of this act or any other condition to which the grant of letters of administration is subject to, and Roman numeral 2, obtain the consent of all the beneficiaries of the estate to which the letters of administration apply. C, subsection 2 and 3 shall not apply to letters of administration granted to Roman numeral 1, a guardian under section 215, except that for cases falling under subsection 215, letters of administration shall terminate automatically as required in section 215 of this act. And Roman numeral 2, the Administrator General under the Administrator General's Act, the Administrator General under the Administrator General's Act. Justification, the imposition of a validity timeline will result in additional costs on the estate to renew, which will expose the estate to additional costs, thereby eroding the beneficiary's legacy. To limit the functions of the executor to 2 years, since in majority of estates, the function of administrator being the collection and distribution of the estate to persons entitled to it, can be carried out within 2 years, and any attempt at increasing it beyond that time will delay the beneficiaries from accessing their entitlement and will result in the executor unreasonably holding onto the estate for personal gain. Limiting the grant to 2 years would put the executor on notice that their role is much limited and they should execute their duties as soon as possible. Providing a total term of 6 years as proposed in the bill would be counterproductive, and when 2 years. 2 years. Really? If I may read the last, limiting the grant to 2 years would put the executor on notice that their role is much limited and they would execute their duties as soon as possible.
Procedure, Madam Chair.
Yes, Honorable Nanda.
Madam Chair, I'm raising on a procedure issue. I have here a report which is signed by members, and it is talking of 3 years. And when I check there, my brother there is reading 2 years, which is not, and I've even confirmed with my colleague there some 3 years. Mine is signed. It's here. That's signatures. So,
yeah, Chair, I think my colleague is not alluding to the fact that after the first report, there was harmonization which was done with the Land Attorney General and the private member mover. And I think he's still holding on to the old report before the harmonization. And probably that's where the discrepancy is arising.
So, Madam Chair, could I have a copy of the harmonized one? Because even I've checked my young iPad, I can't see it.
Chair, this current report we are reading is actually uploaded, and my colleague should be able to access it. Thank you.
Members, this is a report we used actually when processing the first half of this bill. We already have it. So I put the question that clause 39 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 39 as amended.
Question is that clause 39 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 40.
No, new clause. There's a new clause. No, Chair? New clause?
Yes, Chair, we're starting a new clause immediately after clause 39. A new clause reads as follows. Amendment of section 265 of the Principal Act. Section 265 of the Principal Act is amended by A, numbering the existing provision as subsection 1 and substituting for the words the petitioner for probate or letters of administration, as the case may be, shall be the plaintiff, and the person who may have appeared to oppose the grant shall be the defendant. Appearing in the provision, the words either the petitioner for probate or letters of administration, or person who may have appeared to oppose the grant of probate or letters of administration may be the plaintiff in the suit. And B, inserting immediately after subsection 1, the following new subsection. The High Court may refer the parties to a suit under this section to the Administrator General, where the party whose application is the cause of the suit was not required to, and therefore did not have the Administrator General's notice of the application for a grant under Section 5 of the Administrator General's Act. 3, the High Court shall in all matters before the court under this section issue summons to all the persons mentioned in the application for probate or letters of administration to appear before the court as witnesses. Justification: to incorporate the proposals contained in the 2019 Succession Amendment Bill, especially clause 37. Thank you, Chair.
Now, members, the question that the new clause be inserted as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 40.
The question, clause 40 be deleted. Those in favor say aye, the contrary no. Ayes have it.
Clause 41.
41, Honorable Chair.
In clause 41, substitute for the proposed section 268 the following. 268, intermeddling and other acts. 1, a person who intermeddles with the estate of the deceased person commits an offense and is liable on conviction to a fine not exceeding 1,000 currency points or imprisonment not exceeding 10 years or both. 2, a person is taken to intermeddle in the estate of the deceased where that person, while not being the Administrator General, an agent of the Administrator General, or a person to whom probate or letters of administration have been granted to by the court, A, takes possession or disposes of a deceased person's property, B, does any other act which belongs to the office of the executor or the administrator. 3, notwithstanding subsection 2, the person shall be taken to intermeddle in the estate of the deceased person where that person, although designated by the beneficiary of the estate as administrator or appointed in the will as executor, does any other act which belongs to the office of the executor or administrator before he or she has been granted probate or letter of administration by court. 4, subsection 1 shall not apply in cases where the intermeddling is by the spouse or lineal descendant of the deceased person, and it happens before grant of letter of administration or probate in circumstances prescribed in subsection 5. 5, the circumstances referred to subsection 4 are where the intermeddling for the spouse is for the purpose of A, preserving the estate, B, providing for the deceased funeral, C, providing immediate necessities of the deceased family, D, preserving and prudent management of the deceased person's business, including preserving the deceased person's goods of trade, or E, receiving money or other funds belonging to the deceased. The duration, 6, the duration for which a person referred to in subsection 4 may intermeddle in the estate of the deceased person is 6 months from the date of the deceased person's death or until grants of letter of administration or probate, whichever first occurs. 7, a person who intermeddling with the estate of the deceased person, pursuant to section 4, shall immediately report particulars of the property and of the steps taken to the Administrator General or its agent. 8, a person who has reason to believe that the person intermeddling in the estate of the deceased person, pursuant to section 4, has caused the loss or damage to the estate, or there are reasonable grounds for ending the intermeddling, may to the Administrator General or its agent for redress. May report, I believe. Report to the Administrator General or its agent for redress. 9, a person who intermeddles in the estate of the deceased person, pursuant to section 4, subsection 4, shall be personally liable for any loss occasioned to the estate arising from the intermeddling and shall make good the loss caused to the estate. 10, notwithstanding subsection 9, a person who intermeddles with the estate and causes loss shall make good the loss occasioned to the estate, except where the person who causes the loss is the beneficiary under the estate. A portion of that entitlement representing the loss occasioned to the estate shall be applied towards making good the loss occasioned to the estate. 11, a person who intermeddles in the estate of a deceased person beyond the time prescribed in subsection 6 commits an offense is liable to a fine not exceeding 1,000 currency point or imprisonment not exceeding 10 years or both. Justification: to expand the definition of intermeddling to include instances where a court has appointed an administrator or executor. Currently, and even in the proposed amendment, intermeddling can only happen before grant of letters or probate, yet we know that intermeddling can happen even after grant of letters of administration or probate. In order to preserve the estate from abuse before letters or probate is granted, to expand the provision to allow intermeddling in the estate by spouse, children, or a partner of the deceased. There are justifications to limit the intermeddling to 6 months or until letters or probate is granted. To create an offense against a person who intermeddles beyond the time prescribed. To empower the person to make an application to court to end intermeddling where the estate is being mismanaged. To require a person who intermeddles in the estate of the deceased person to make good the loss caused to the estate. Thank you, Chair.
Now, on page 56, under 7, a person who intermeddles, I think not intermeddling, it should be intermeddles.
Yes, that's true, considered.
Yes, Honorable Andal.
Madam Chair, under 10, we're prescribing what the person will be liable to. No, 11. But under 9, we're talking about a person making good to loss. If you look at 9 standing alone and 11, Madam Chair, I wanted to propose to the Chair that we merge that a person who intermeddles in the estate of disease beyond the time prescribed in subsection commits an offense and is liable. This is exceeds. But what about the one who does 9? A person who intermeddles in the estate of a disease pursuant to subsection shall be personally liable for a loss arising from the intermediary and shall make good the loss caused to. Why don't we penalize this person? Only, why do we look at the loss and not penalize the person also, so that you can make this person not to try to meddle? Because if he knows the loss, he will only pay the loss of the estate. But if he's also penalized beyond the loss, then it will be a deterrent for this person to not intermeddle in the estate. So I wanted to propose that even on 9, we add a penalty in addition to making loss good.
No, I don't know whether that's necessary. Under 9, the presumption is that the matter will go to court and the determination will be made about how much to refund. So I put the question that clause, a new clause, is it a new clause? Clause 41. Put the question that clause 41 be amended as proposed. Those in favor say aye, the contrary no.
Clause 41 as amended.
Question that clause 41 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 42.
42, Honorable Chair.
Clause 42, substitute for the proposed section 270 with the following. 270, disposal of property. 1, subject to section 27 and 36(6), an executor or administrator may, with the written consent of the surviving spouse and all the lineal descendants of the estate, dispose of the property of the deceased either wholly or in part. 2, where a beneficiary of the estate is a child, the consent required in subsection 1 shall be given by the guardian of the child, and where the guardian of the child is the executor or the administrator, the consent shall be granted by court. 3, the executor or the administrator shall account to the estate the proceeds of sale. 4, in disposing of property under this section, first option shall be given to the beneficiary of the estate to purchase the property. 5, an executor or administrator shall not be eligible to purchase property of the estate except where such executor or administrator is a surviving spouse or a lineal descendant. 6, any disposal of the property belonging to the estate of the deceased person in contravention of this section shall be void. Justification to exempt the disposal of matrimonial homes from sale, to impose restriction on the sales of property of the deceased person, to bar the executor or administrator, as the case may be, from purchasing the property belonging to the estate he or she is administering or executing, to impose an obligation on the executor or administrator to account to the estate for the proceeds arising from the sale of property, to grant a preemption rights to a beneficiary of the estate to purchase the property before it is offered to a third party. And finally, to incorporate the proposal made to section 270 under the 2019 Succession Amendment Bill.
Now, honourable members, I wanted to remind you that earlier we had agreed that instead of the word child, we use the word infant, because a child does not need a guardian. This is someone who's 17 and below, so please let it be changed wherever it occurs to the word infant. Honourable members, I put the question that clause 42, that this is a new clause, that a new clause be inserted as proposed. Those in favor say aye, the contrary no. Ayes have it.
Chair.
The question, clause 42, to stand part of the bill. Those in favor say aye, the contrary no. Ayes have it. There's a new clause.
Insertion of a new clause. After clause 42, insert the following new clause. Repeal of section 271 of the Principal Act. Section 271 of the Principal Act is repealed. Justification: repeal section 271 is to ensure that the executor or the administrator cannot sell, I believe sell to him or herself property belonging to an estate he or she is executing or administering, since this will be a conflict of interest. Consequential, then the final one is consequential amendment arising from the amendment of section 270 of the Succession Act in clause 42.
Members, please.
The current section 271 says purchase of deceased property. It says if an executor or an administrator purchases either directly or indirectly any part of the property of the deceased, the sale is voidable at the instance of any other person interested in the property sold. Now you want us to remove this, yet this one helps to avoid an executor or an administrator not to purchase. And I think if we delete, we're saying the executor and administrator should purchase, and which we are saying it shouldn't.
Yes, Honorable Salim.
Madam Speaker, to address my senior colleague's concern, we are creating an exception. We are saying you can only purchase if you are a surviving spouse or a lineal descendant.
No, Honorable, this 27 was talk about the executor or administrator, not the spouse. This is a person who has responsibility for the estate, not the spouse.
Yeah.
Yes.
I think the clarification I want to give the Honorable Nandala is that the proposal by the committee is really intended to outlaw any purchase of property by an executor or administrator, because the current provision actually merely makes it voidable. In other words, the current provision is permissive because they use the word voidable. Now the proposal is to completely outlaw and bar the executor or administrator from from purchasing property he or she is administering or executing. I think that's the clarification I wanted to make.
Chair, I think the justification there is that we are already barred in clause 42 the executor from selling to himself, and that's the reason why we are deleting 271, because the clause in clause 42 we had already outlawed him from selling to himself.
Good.
It's
And members
redundant.
put the question that clause 42 be amended as proposed. No, a new section be introduced as proposed. Those in favor say aye. The contrary, no. I submit.
Clause 43.
43, Honorable Chair.
Chair, 43, it's being substituted the following. Amendment of section 272 of the Principal Act. The Principal Act is amended by A, renumbering the current provision as subsection 1 and B, inserting immediately after the following. 2, notwithstanding subsection 1, there are more than one executor or administrator, probate or letters of administration may, with the consent of all the other executors or administrators, be granted to a sole executor or administrator or any other number of executors or administrators as the case may be. Justification: to require the consent of all executors or administrators in a situation where there are more than one executor or administrators, but one or a few of them are interested in obtaining probate or letters of administration.
Honorable members? Yes.
I was trying to consult my brother Basarwa. How do you, is it consent? I think should be written consent. The justification, Madam Chair, consent cannot be, because if it is someone can give a consent in a bar, and tomorrow when they go to court, there will be a problem. So I think here we should add the word written what? Consent. And I've been consulting my brother Basaro. It looks he agrees with me. Chair, I want to propose written consent.
With the written consent.
Chair, we will take the wisdom of the senior member. Thank you. We concede for written
that's
consent.
amendment. I put the question that clause 43 be amended as proposed. Those in favor say aye. The contrary, no.
Clause 43 as amended.
Questions clause 43 as amended do stand part of the bill. Those in favor say aye. The contrary, no.
Clause 44.
44. Honorable Chair.
Clause 44, substitute for the proposed section 273 the following. 273, survival of executors or administrators. Upon the death of one or more executors or administrators, the surviving executor or the administrator shall, see, in the case of an estate with immovable property, with the consent of beneficiary of the estate, and with leave of court, continue as executor or administrator of the estate. D, in the case of an estate with movable property only, continue as executor or administrator of the estate. Justification: for clarity, to allow an executor or administrator to continue notwithstanding the death of one or more executors or administrators, save for the estate with immovable property where they need an order of court. And finally, to ensure that a surviving executor and administrator should seek the consent of the beneficiary before applying for leave of court to continue an administration of an estate.
Members, put the question that clause 44.
You read it.
Madam Chair, since we have adopted written, even here the consent should be in case
Okay.
written. And I think if the chair consents, that would be better.
Okay. Members, with that adjustment, I put the question that clause 44 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 44 as amended.
Questions that clause 44 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 45.
Put the question that clause 45 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 46.
Put the question that clause 46 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 47.
47.
Clause 47, there is substituted the following. A replacement of section 311 of the Principal Act. The Principal Act is amended by substituting for section 311 the following. 311, the procedure in respect of the share of a child in intestacy. One, where a person entitled to a share in the distribution of the estate of a deceased person is a child, the executor or the administrator shall deliver the share of the child to the guardian of the child. Two, the guardian of the child shall manage the property delivered to him or her in subsection 1 in a prudent manner and shall A, apply the property for the benefit of the child. B, take reasonable steps to safeguard the property of the child from loss or damage. And E, annually account in respect of the child's property to the surviving parent in any court or any other person as court may direct. 3, except where there is an order of court to the contrary, the guardian shall within 6 months of the child attaining the age of 18 years transfer all the property in his or her custody to the child. 4, notwithstanding subsection 3, a guardian or any other person who considers that a person to whom a property will be transferred to pursuant to subsection 3 is not fit administer his or her property, the guardian or other person may apply to court to determine the suitability of the person to manage his or her property. Justification: to align the provision with the provision of the Children Act, which required appointment of a guardian to take charge of the child's property and to administer the same. To provide for a time within which a guardian shall transfer property to a child upon attaining the age of majority. And finally, to allow court determine the suitability of a person to manage his or her property.
Honourable members, again, I am taking issue with your removal of the word minor. Minor in law means you have 17 and below. So we cannot substitute for anything else, really. And then there's under subsection for your proposal, there's a what 2 is missing, is not fit to administer. Yes, Honourable Nandala.
Yeah, Madam Chair, that's true. Minor, we need to maintain the word minor. But also I wanted to seek a clarification from the chair of the committee. What about those who have unstable minds, they are not minors, those are people who are beneficial in the estate. we have not made a provision for them. What? Those who are capable, but they are beyond the age of a minor. How do we take care of their interests? Because they will need money for they will need some of the assets maybe for maintenance, for what, mention it. So, Madam Chair, I wanted the chair to think about it so that maybe we could add the minor and those who are capable. Above 18, but capable.
Chair, in the wisdom of the committee, they saw that, first of all, under clause 4, not fit to administer and in a way catered for that, but also the law with respect to persons of unsound mind, there's an act which actually deals with administration of estate of persons of unsound mind, which elaborately also addresses this. So that was the reasoning, yeah.
Chair, the person may not necessarily be of unsound mind, but may be sickly, and that sickness makes that person incapable of managing the property. However, Chair, the point I want clarification for is under subsection 2B. Take reasonable steps to safeguard the property. Take reasonable step. Is reasonable step defined somewhere in the law? Because if it is not defined, then you leave it to the guardian to decide what is reasonable and what's not reasonable. So I just want to be put at peace that somebody cannot use this word reasonable. Thank you.
Honorable Chair, where is he gone? Yes.
Chair, to try and address the concerns of Mama Cecilia, whenever the law uses the word reasonable, they take the standard of an ordinary person on the street. And usually that statement is used on the basis that human nature is not necessarily perfect. So you are likely to have situations where imperfections may occur, but usually reasonable is a question of fact. What is reasonable in the circumstances? So it could be a very broad term, but sometimes it's unavoidable in legislations of this nature. And there are many statements of that nature that appear in many of our laws, just for purposes of ensuring that nature may not be entirely perfect. That's usually the import of that statement.
Yes, Attorney General.
Madam Chair, I wish to depart from the submission of my colleague, Honorable Asuman. In this particular case, I would wish to agree with the proposal of Mama Cecilia and Honorable Nandala. When you remove the word reasonable, it remains take steps to safeguard the property, which creates an obligation on this person to take steps to safeguard the property. But if you say reasonable steps, depending on his state of mind, assuming he wants to acquire that property himself through someone else, he can put a feeble fence or defense, which will be overrun, and then he will say, we lost the property. We shall have embedded the weakness in the law to allow people to manipulate the system. On that basis, I would propose we remove the word reasonable and go with the word take steps, in which case it is incumbent upon whoever is in charge to show which steps he has taken to safeguard the property. I beg to submit.
Honourable members, put the question.
Madam Chair, I want to thank the Attorney General for agreeing very fast, because you can get a judge who can close the eye and say the person was reasonable. For example, Kavuma, if you get Kavuma.
Honourable members, put the question that clause 47 be amended as proposed. Those in favour say aye, the contrary no.
Clause 47 as amended.
Question that clause 47 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 48.
Put the question, clause 48, Honourable Chair.
Chair, in 48, substitute for clause 48 the following. Amendment of section 331 of the Principal Act. Section 331 of the Principal Act is amended A by substituting the reference to Tanzania or Kenya appearing in the head note and in the section with a country other than Uganda, and by substituting the Supreme Court of Kenya or High Court of Tanzania and appearing in subsection 3 with the court of a country other than Uganda. Justification: to clarify and better drafting, since the old section 331 of the Principal Act need not be amended. The areas that in need of amendment are those outlined in clause 40 of the 2019 government bill, and this should be adopted.
Now, members, put the question. Clause 48 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 48 as amended.
Questions clause 48 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 49.
49, Honourable Chair.
In clause 49, substitute for the proposed amendment to section 332 the following. 332, liability of executor or administrator for damage or loss to estate. 1, an executor, executrix or administrator who A, misapplies the estate of the deceased person, B, misappropriates or cannot account for the proceeds accruing to the estate of the deceased person or to a beneficiary of the estate, C, subjects the estate of a beneficiary to loss or damage, commits an offense and is liable on conviction to imprisonment for a term of 3 years or to a fine not exceeding 1,000 currency points or both. 2, the court shall, in addition to the penalty under subsection 1, order the person to make good the loss or damage occasioned to estate or beneficiary. Justification: to extend the provision to cater for beneficiary, thereby imposing a duty of care towards the individual members of the estate of the deceased person. To expand the circumstances under which a person will be criminally liable for loss. Finally, to adopt the proposal made in clause 41 of the 2019 Succession Amendment Bill, especially on the penalty for breach.
Yes, Honourable Nandal.
Madam Chair, I went to Soga College, Mwili. I never did the English. Now, since you have said ex-tutor and you have brought ex-tutrix, I think that one is a woman or another. I don't. But then also, if you are talking of an administrator, then you should also talk of administratrix.
Yes, that one.
Yes, that one.
Yes.
So, Madam Chair, you agree with me?
Yes.
Thank you very much. So, I wanted to ask the chairman, why did you forget that one, administratrix? So, I want proposer to add that.
I think it is really in order. Yes. Yes, Honourable Gwar.
Chair, my concern is the way it's drafted. Maybe people like Nandala would have helped me because he's a professional accountant. 1C, subject to the estate or beneficiary to loss or damage, commits an offense and is liable to conviction or imprisonment for a term of 3 years or to a fine not exceeding blah blah. Now, Chair, my concern is it depends on the gravity of the loss, and particularly when you are talking of mismanagement, loss or damage, there must be accountability to quantify the loss or the damage. Now, where the whole estate has been mismanaged and there is no clear accounts to really put your fingers or to identify the exact amount of loss, the liability or imprisonment of only 3 years or whatever, I find it difficult. Maybe we could make it even more stringent because we are not sure of the amount of money that would have been lost during this period of mismanagement. So I'm not very comfortable with the way it has come out, Madam Chair.
What are you proposing? Honorable Ogar, what are you proposing?
I'm proposing that the Attorney General translate my explanation into a legal.
Chair, again, if it can be of benefit, in 2, just after what my senior Mama has read, the court shall, in addition to the penalty under subsection 1, order the person to make good the loss or damage occasioned at the estate of the beneficiary. So there is an indication with the wisdom of the Land Attorney General, the translation can be pay back or compensate or the remedy of restitution. Thank you, Chair.
No, but the word make good is not, is that a problem? It means you must replace.
So, Chair, the provision as it stands, in our view, is in addition to the penalty that yes, I think Mama is in consent.
Okay.
It is as it stands. The other one was, by the way.
The operational award is in addition. Okay, the members have put the question. Yes. Yeah, yes, I think he did.
Agreed.
Yes. Okay, please switch to the amendment. About executrix, administrator, administratrix. Just switch the microphone. Yes. Remember, let's add the word after administrator, let's add the word and administratrix. And then I put the question that clause 49 we amended as proposed. Those in favor say aye, the contrary no. I have it.
Clause 49 as amended.
Question is that clause 49 as amended do stand part of the bill. Those in favor say aye, the contrary no. I have it.
Clause 50.
Clause 50, Honorable Chair.
In clause 50, redraft the proposed subsection 1 as follows. 1, an executor or administrator who occasions loss to the estate by neglecting to do an act or omission which causes loss to the estate of a deceased person or to a beneficiary under the estate of the deceased person commits an offense and is liable on conviction to imprisonment for a term of 3 years or to a fine not exceeding 1,000 currency points or both. Justification: to expand the provision to include the beneficiaries in addition to the general estate, thereby imposing a duty of care towards the individual members of the estate of a deceased person. To extend the provision to include all negligent acts or omissions done by the executor or the administrator. Finally, for consistency, to harmonize the penalty prescribed in section 332 and 33 of the Succession Act, and then to adopt amendments proposed in section 333 under the 2019 bill.
Members, question?
Madam Chair, we're defining the only way how you can be punished. We're saying by neglecting or omission, but the others, this is wrong. What we should say, which I'm saying that anybody, so we say an executor or administrator, who occasion is lost to the estate of a deceased person, we remove all those who are neglected, because you are now saying, you will say, I never neglected. I never made omission, but a loss has occurred by his acts, which may not be as omission or neglect. So, Madam Chair, it can be even intentional. So I wanted to propose that an executor administrator who occasions loss to the estate of the deceased person or the beneficiary under this, so we remove the word neglect and omission.
Yes, Honorable.
Madam Speaker, I beg to disagree with my senior colleague. When you say you remove the word neglect or omission, you are creating direct liability without subjecting it to the test. The proviso for neglect or omission in law, which we call misfeasance or non-feasance, failing to do or doing wrongly, means there is a subjective test. If we remove it, we open it to abuse. I beg to submit.
Honorable Nanda, for instance, if I'm the administrator and I'm required to pay taxes, and then I omit to pay those taxes for 3 or 4 years, and the revenue authority grabs the property, that's by omission. Okay, for the members, I put the question that clause 50 be amended as proposed. Those in favor say aye, the contrary no. I have it.
Clause 50 as amended.
Questions clause 50 as amended do stand part of the bill. Those in favor say aye, the contrary no. I have it.
Clause 51.
Put the question clause 51 be, do stand part of the bill. Those in favor say aye, the contrary no. I have it.
Clause 52.
52 on over here.
In clause 52, in the proposed subsection 2, substitute for the words to a fine not exceeding 24 currency points or imprisonment not exceeding 1 year or both, the words imprisonment for a term of 3 years or to a fine not exceeding 1,072 currency points or both. Justification? To enhance the penalty imposed to make the provision deterrent enough. And finally, to harmonize the prescribed penalty with similar penalty prescribed in the proposed amendment to section 331, 332, 332 of the Succession Act.
Members, put the question that clause 52 be amended as proposed. Those in favor say aye, the contrary no. I have it.
Clause 52 as amended.
Questions clause 52 as amended do stand part of the bill. Those in favor say aye, the contrary no.
Clause 53.
53 on over here.
Clause 53 is amended in paragraph A by inserting the following: minor, a reference to a child. That was, I think, been dealt with before.
I thought we had agreed.
We can just, yeah, we can adjust it.
A minor is a minor, please. You harmonized it? Okay, wherever you have put the child, replace with the word minor. So the
B, by inserting immediate after paragraph B the following. C, by substituting for the term. A district delegate appearing in part 31 of the Act, and in other part of the Act, the term chief magistrate or magistrate. B, lunatic, wherever it appears in the Act, the term person with mental illness. C, minister, whenever it appears in the Act, the term attorney general. And D, first schedule, second schedule, third schedule, and fourth schedule. Whenever it appears in the Act, the term schedule 2, schedule 3, schedule 4, schedule 5, respectively. Justification for clarity and completeness. And also to adopt the proposal in the clause 53 of the 2019 bill. Chair, we have other insertions.
Let's finish with the existing clause. Put the question of the clause 53 be amended as proposed. Those in favor say aye, the contrary no. Let's have it.
Clause 53 as amended.
Which does clause 53 as amended do stand part of the bill. Those in favor say aye, the contrary no.
Clause.
New clause.
A new clause, insert the following new clause immediately after clause 53 as follows. Insertion of a new section 340, 341, 342 in the Principal Act. In the Principal Act, the Principal Act is amended by inserting immediately after section 339 the following new section. Amendment of Schedule 1 to this Act. Attorney General shall, with the approval of the Cabinet, by statutory instrument, amend Schedule 1 to this Act. The Principal Act is amended by inserting immediately after section 340 the following new section. Transitional provision. Section 6, 7, and 49 of this Act shall apply to an estate of a deceased person who died on or after the 5th April 2007, where the estate of that deceased person is not distributed at the date of commencement of this Act. It's another insertion of a new Schedule 1 in the Principal Act. The Principal Act is amended by inserting the following schedule appropriately. Schedule 1. A currency point. A currency point is equivalent to 20,000 Ugandan shilling. Justification: to prescribe a currency point, to harmonize the proposed amendment in the 2018 bill and 2019 bill on the position of the schedule on currency point, to empower the Attorney General to amend the first schedule to this Act whenever it is necessary, to provide a transitional provision, and finally for clarity, consistency, and better drafting.
And the members' question is that new clauses will be introduced. Yes, Honorable Obar.
Chair, I just want some clarity on this. I want to know if the minister comes up with the amendment to the schedule, can we be assured that it can be laid at table in Parliament so that we can follow up? Because this is a very important law. I would not want the amendment to end with Cabinet. There must be something compelling the Attorney General to lay it on, without necessarily notifying us, but lay it so that we are aware that this is how the schedule has been amended.
No, Attorney General.
Madam Speaker, that amendment would be by form of statutory instrument, and it is the practice that the minister concerned lays it on table. But that's how it is with all the other ministries where they are asked to make statutory instruments. They lay them on table. Why would we provide specifically for this one when all the others are not provided for? It is a practice that has been evolved over time, and we do it here in Parliament.
Yes, Honorable.
The learned Attorney General is right in stating that that's the practice. But I think the concern of Mama Cecilia Ogwal, which really should run even to other pieces of legislation that we pass, is the element of notifying Parliament about the various statutory instruments that are issued by the ministries. Right Honorable Speaker, Chair, you recall how we demanded for the statutory instruments on COVID from the Attorney General, and they were not forthcoming until you made a directive and they were tabled here. Actually, some have never been tabled. So I think going forward, each piece of legislation that we consider, the element of requiring the line minister to table for information purposes, not necessarily debate, because it will then undermine the concept of subsidiary legislation. But for information purposes, it would be important that that becomes part of our laws, to have them formally tabled here for purposes of information.
I appreciate the submission of my brother Asuman. Like I said, we do not have a law providing for tabling, but the practice has evolved that all ministers who make statutory instruments do table them in Parliament. Now, in the event that you feel there is a mischief that we need to cure by providing specifically in the law that these statutory instruments should be laid, maybe we should make a law to that effect, comparing all the other ministries, other than embedding it in one law, targeting only the Attorney General's office. I beg to submit.
No, but Attorney General, this is an issue of accountability and exercise of authority. I don't see why you are resisting just saying, I will bring this instrument here. Because you are dealing with people's estates, people's property.
Madam Speaker.
And I don't know when you bring the other law which you are thinking, you're just thinking now.
Madam Speaker, it has just come up, and with your, now that it has come up, Madam Speaker, I can submit on it comprehensively sometime next week. I will ask my drafts people to do that, so that we liaise with the Business Committee of Parliament and we agree on how best to proceed.
Chair, I would not like the Attorney General to think we are targeting the Attorney General, but Chair, this particular bill which we are about to pass into law is very important to all of us, and we cannot afford to make a mistake. There could be circumstances when the amendment could drastically change what you originally had intended it to be. And that drastic change in the original position is my concern. So I would like the Attorney General to understand that this is done in good spirit. Not that we are targeting your ministry, but if you feel it is necessary, I think the Speaker can guide the House, and we can come with a substantive motion now requiring all ministers. We can do that. But for now, for this particular law, because it concerns a person who has already, the property of a person who has already passed on, we insist that any variation be tabled in Parliament.
Yes, thank you, Madam Chair. The gravity of this bill, Madam Chair, differs from all others. This is about property of the dead. I don't see why the Attorney General doesn't set precedent with this one, in that others can also be borrowing from this. Madam Chair, we can set precedent and begin with this. Others can continue. It has a very, very grave impact to just make amendments there by the minister and keeps quiet. Honorable Basairo has cited a scenario of the COVID soaps, where the Attorney General office took time. The gravity of this bill, Madam Chair, we need to set a precedent. Thank you. That's the information.
Yes.
Madam Chair, for clarity, Mama Cecilia, when I say the targeting, it's not in bad faith. Yeah. Two, Madam Chair, it is wrong for us to say this law is more important than all the others. When we say the gravity of this law, we are creating the impression that all the other laws, which also permit ministers to make statutory instruments, are less important than this. What I would agree with, and which I think is proper and in good faith and for accountability purposes, is for us to pass a law asking every minister who has been given authority by an existing law to pass a statutory instrument to lay the same on the table, so that it is mandatory for that minister to do so. I beg to submit.
Now, Honourable Member, Honourable Attorney General, for instance, we have the Uganda Communications Act, which requires the minister to lay the regulations here before they can come into force. It's not more important that this one's not less important. I don't know why you're resisting, because this is an issue of accountability. Then you can make the other law for everything else. Because now you're going to go to cabinet to discuss whether you should. They might say don't do it, or they might say now you got the draftsman. Let me propose what we could say. The statutory instrument referred to in subsection 1 shall be laid in Parliament. Just that. Okay.
Chair.
Yes.
Chair, there is a proposal, just almost exactly as you stated, that the statutory instrument referred to in subsection 1 be laid in Parliament for information. I guess maybe to avoid the aspect of having
so that
a
we don't have
debate
to dismantle it. That's okay. For me, I have no problem. Yeah. Okay, so now we agree that that is the necessary amendment. Yes.
Madam Chairperson, I thought it was the standard procedure and requirement that all statutory instruments operationalizing laws that are passed by this House must be laid on table. So when we do this for just a select pieces of legislation and leave out those that may not contain this clause, are we saying that it is only for those where we have spelled it out that should be tabled before the House, and that others, that it is okay that others should not? I thought, Right Honorable Speaker, that it should be a standard requirement that no statutory instrument should go into effect unless the minister has laid it on table. I beg to submit.
Are you going to propose the Statutory Instrument Act here? Is that what you're saying? That requires you to move a motion, bring it to here, we debate it, then you go to draft it.
Honorable Chair, what I'm saying is that it is not necessary at all, because this is the existing procedure of Parliament. This is a standard requirement that all ministers must lay the statutory instruments on table.
But why are you avoiding stating it? Why are you avoiding stating it?
Chair, I think Honorable Jova is right. It is supposed to be, it's actually a conventional practice in Commonwealth parliaments. The challenge we face in our own situation here is that that practice is abused. In fact, you rarely find ministers laying before Parliament statutory instruments they have issued. And that is the challenge. If there is no culture of voluntarily laying these instruments on the floor of the House, then you have to adopt the other option. Either we make it mandatory in every piece of legislation that we pass, the way we are proposing in this particular succession bill, or we have a motion before this House. That motion will be extracted and served on the executive, and that becomes the modus operandi. Otherwise, virtually every month or thereabout, ministers are issuing statutory instruments. When you go to the Gazette, they are there, and Parliament is not aware of them. So I think that's where the problem is. There has been reluctance on the side of the executive to bring those instruments here for purposes of information.
Thank you, Madam Chair. We need to compel the minister to update information considering the gravity of this bill, Madam Chair. Let's compel them. Otherwise, the practice has been abused, as the senior colleague has cited, Madam Chair. I beg to submit.
Honourable members, I want to appeal to you to remember that this is the house that makes law for everybody. The people who need this law cannot come here. We are the ones who are here. If we see a problem, we should deal with it. They can bring another law later, but for now, we are dealing with the Succession Act. And there was a proposal. Can you restate your proposal, Honourable Chair, so that we move?
It's the amendment of Schedule 1 to this act. It says the statutory instrument referred to in subsection 1 shall be laid in Parliament for information purpose. Okay. Within a month. Yes.
Madam Chair, the time frame is very, very important for this particular law. Madam Chair, we recall legislation called the Domestic Violence Act, legislated in 2010. It took another 2 years for some sections of the law to be implemented. And so if we do not specify the time frame, sometimes it affects the work of the ministers and also the implementation of the law. So it took us another effort to get the minister to come with regulations on that bill before it could be implemented. So I beg to support what members are saying. We need time frames in these bills, in this act.
Can I also remind you about the law on Islamic banking? We are still waiting for action from the government. How many years? 4 years since we made the law. Yes.
Madam Chair, there's a proposal that the time frame could be 45 days from the time of
I think let's not confuse two issues here. There is time within which to make the regulations. And then there is time within which to notify Parliament. So we must be very specific on what we want to discuss. If you are talking about I think the debate on the floor at the moment is notification of Parliament when the statutory instrument has been made. So if a minister makes a statutory instrument, when should they notify Parliament? Is it within 1 week after they have been made and gazetted? Is it within 45 days? That must be very clear. The other aspect is if a statute, if an act of Parliament obligates a minister to make regulations, when should those regulations be made? I think that's where we need to focus for purposes of this debate. Because, Chair, I see we are confusing the two things. A law mandates a minister to make regulations, they don't make them. Then where regulations are made, this Parliament is not notified. We need to be very specific.
Now, what is the import of gazettement? If the instrument is gazetted, it means it's ready, isn't it?
Yes.
So the House should be informed immediately upon gazettement.
And there's no problem, Chair, if we want to go that way, then perhaps the proposal being made is that once a statutory instrument has been made and gazetted, then the minister should perhaps at the next sitting of parliament lay it before the house from the date of gazetting.
I think let's say upon gazettement. As soon as, yes, as soon as it's gazetted, it may not be the evidence, but when it is gazetted, so it must inform us. I think let's use upon gazettement.
Chair, that what you said makes sense. That if it is already gazetted, what is left then?
Yeah.
It should be the house should know because the public is already aware. Thank you, Chair.
Let's say upon gazettement, please. Let's not. So, Honorable Chair, please make the proposal. Want to move?
Madam Chair, as the chair is trying to make a proposal. You see, some people mistake Gazette that everybody is aware. Those people who are aware of the Gazette are those who read it, like my advisor here. But we villagers, we don't read the Gazette. But when it's laid in the house, then the people of Sironko will know that the law has been made of this nature. So, Madam Chair, I think my younger brother, the Attorney General, should agree and say, upon gazettement, this should be laid in the house.
Because it will not come into effect until it is gazetted. So once it is gazetted, it should be or notice the public and therefore come to the house. I think upon gazettement is okay. Okay.
Chair, we are ready with the
Okay.
proposal. The statutory instrument referred to in subsection 1 shall, upon publication in the Gazette, be laid in Parliament for information.
Okay. Is that okay? Yes. Dr. Chris.
Madam Chair, I think that extra word for information should be deleted. Because you see, you can lay the instrument on the table and we may have some issues with the instrument. So you shouldn't tie the hands of Parliament. So it should be laid on the table and you just stop there. It will be laid in the Parliament, full stop. Yes.
Okay. Okay.
Chair, I totally understand where my brother is coming from, but there's also the principle of deferral. Because what the law envisages here is that this is the mandate of the minister, but we need to know. But when we find problems with it, we can refer it back to the minister. Instead of, the challenge we have with trying to get into all this is that we will end up actually getting into legislating on statutory instruments, subsidiary legislation, which is going to be opening up a Pandora box.
Other members, unless the law states it, we normally do not go into dismantling those. We note them for action. We don't normally debate them. No, we don't.
Chair, information actually can lead us to an obligation which we don't want, because not everybody reads the Gazette. So when you say we lay for information purposes, I don't think that is accurate. Madam Chair, we want regulation laid on table as soon as it has been published in the Gazette. That's all. And it stops there. But this guy, for information purposes, I think that is wrong. Because if I look at the Gazette and I find that the Gazette does not seem to carry the message which we passed here, then it is up to me to carry the Gazette and say, Right Honorable Speaker, here is the Gazette and here is the law we passed. There is no comparison, and we are unhappy because this is not what the House passed.
Now, honourable members, let's not complicate this matter. We are not reinventing the wheel. The instruments are laid here so that we can know about them. But we don't take them to the committee to say, did he do it properly? Is it wrong enough? Please, let's not complicate this matter. Let lay, just lay, upon Gazette. Honorable Makumot, please state the position and move quickly.
Chair, the proposal is that the statutory instrument referred to in subsection 1 shall, upon being laid, upon publication in the Gazette, be laid in Parliament. And when we stop there.
Yes. Okay. Honourable members, put the question that clause 50, 54 be amended as proposed. Those in favor say aye. The contrary no. Is it 54 or 53?
New clause.
A new clause introduced as proposed. Those in favor say aye. The contrary no. Ayes have it.
Clause 54.
54, Honourable Chair.
Clause 50, for clause 54, there's substituted the following amendment of first schedule to the Principal Act. The first schedule to the Principal Act is amended by renumbering the schedule as Schedule 2. Justification, it is a consequential amendment arising from the rejection of the proposal to delete Part 3 of the Principal Act.
Members have put the question.
Consequential amendment, the other justification, Chair, is consequential amendment arising from the insertion of the new schedule on currency points as Schedule 1. And final, to adopt the proposed amendment in the 2019 bill.
Members have put the question that clause 44, 54 be amended as proposed. Those in favor say aye. The contrary no. Ayes have it.
Clause 54 as amended.
Questions clause 54 as amended do stand part of the bill. Those in favor say aye. The contrary no. Ayes have it.
Clause 55.
55, Honorable Chair.
Clause 55, they substituted the following. Amendment of schedule, second schedule to Principal Act. The second schedule is amended A by renumbering the schedule as Schedule 3. B, in paragraph 1, by substituting for paragraph 1 the following. In the case of residential holding occupied by an intestate prior to his or her death as his or her principal residence, the following categories of persons who were normally resident in the residential holding shall be entitled to occupy it. A, the spouse of the intestate person. B, a minor child of the intestate person where the child attains 18 years of age, he or she shall be eligible under paragraphs C as may be applicable. C, a lineal descendant who is above 18 years of age, who is undertaking studies or is unmarried. D, a lineal descendant who has not...
I think we deleted that part.
We deleted. We concede that consequentially. D, a lineal descendant who has not been married or who is by reason of mental or physical disability incapable of maintaining himself or herself until or she marries or upon the cessation of disability, whichever comes first. C, in paragraph 8, by numbering the provision as subparagraph 1. D, by substituting for paragraph 1 of paragraph 8 the following. Where the occupant is a spouse, upon marriage or upon the spouse voluntarily leaving the principal residence or misusing it and putting it in disrepute. E, by substituting for paragraph 1, C of the paragraph 8, the following. C, where the occupant is a minor child of the estate of the intestate person upon the attainment of 18 years of age and on attainment of 18 years of age where applicable, subparagraph 1, C, is it C? C-A? Or paragraph 8.2 shall apply as the case may be. F, by inserting immediately after paragraph 1C of the paragraph 8 the following. CA, where the occupant is a lineal descendant of the intestate person and is above 18 years of age, but below 25 years of age at the time of death of the intestate person, upon the attainment of 25 years of age, choosing to undertake studies or on becoming married, whichever is the earliest. G, in paragraph 8, by inserting a new paragraph 2 as follows, where the intestate person is survived by a lineal descendant who has the disability specified in paragraph 11D, and who is dependent on the intestate person for his or her livelihood, the lineal descendant who has a disability shall be entitled to occupy the principal residential holding for the duration of his or her lifetime, except where provision for accommodation of that lineal descendant at the same station of life is made. H, in paragraph 10, by substituting the word not exceeding 6 months or a fine not exceeding 1,000 shillings or both with not exceeding 3 years or a fine not exceeding 72 currency points or both. Justification, the proposal to delete the second schedule is rejected since it is overtaken by the amendments proposed in section 7, which included female intestates who had previously been excluded, and to revise the percentages of distribution of the estate of an intestate to include the proposals made in 2019 succession bill as prescribed in clause 46. Chair, there are other new insertions. I don't know.
Okay. Yes, Honorable.
Madam Chair, since under B1, A, we are defining a spouse. That one is entitled. Then B, a minor. Then C, a person who is above 18 years old, who is undertaking studies and have removed unmarried. But D is is confusing me. Apart from the one who is mentally or physically disabled, but when you say incapable of maintaining himself or herself until he or she married, oh, I've understood that one now. This is concerning those who are disabled. But H, the fines are confusing. You are saying not exceeding 6 months or a fine not exceeding 1,000 shillings or both. Then you say not exceeding 3 years or a fine not exceeding 72 carriage points. Now, one is in shillings, another one is in carriage points. I wanted the chair to assist me to understand why the two. Why don't we just make one penalty, which is very clear, including currency point, not shillings?
That's why he's substituting for the word shillings, the currency points. The original, I think, was in shillings. Yes, Honorable Ogwal.
Chair, that particular amendment, we seem to be measuring the normality of a child to marriage, because I don't know why we are using it as a condition that the lineal dependent who has not been married, what does that mean? Then, or who is by reason of mental, that one is understandable. But when you continue saying until he or she marries, so you are actually now tying marriage to a normality of a child. Maybe my understanding of the law, because I'm a villager, really, I haven't learned. I'm not a learned citizen. But I think we need some clarity there. Does marriage have anything to do with demonstration that a child is normal? And in this case, you have not specified, does it include both boys and girls, men and women, or what is it? Am I matured only when I'm married, or my children like Nandala can only prove to me that it's normal when he's married? So, okay.
Chair, it looks like our senior mother legislator anticipated the mind of the chair in anticipation. Chair, we intend to actually remove all those references to unmarried in C, also in D, where it says who has not been married, and also until he or she marries. We intend to remove that because I think that had been resolved earlier. The fear is that you could actually have somebody who is 90 years unmarried still staying in. So in the wisdom of the committee, I think we are proposing that consequentially because of what had been this.
So you tell us where you're removing it from. Tell us where you're removing it from so that we can take a vote on it.
So if we go to clause 55 and you go to that amendment of section of a section schedule to the Principal Act, on page 55 actually, that part C, a lineal descendant who is above 18 years of age, who is undertaking studies, or unmarried. That unmarried bit, we are removing it. And then the following D, a lineal descendant who has not been married, that part, no, who has not been married, is also being taken out. And the following second last paragraph, where it starts ourselves until he or she marries or upon the cessation of the disability, whichever comes first. So I think and it's the concern of senior mama.
Okay, no members.
Again, that one we have agreed. But how do you determine disability, incapability? Because I can have a son, he decides to say, I'm mad until he stays in my house. So who measures the, is it through medical or what? We need to understand, because how do you determine the disability which can justify somebody to continue to live in a certain home? And we need to understand, or even somebody's home. Your inability, we want to know who determines inability, disability and inability.
Honorable Chair.
Yeah, our understanding is that in the Disability Act, this is clearly defined. More so, we think disability is a medical issue, it is a capacity issue. In many jurisdictions, actually, it's a medical opinion on permanent disability and among other things. So I don't know whether, but in the case of a will or so, I don't know whether this is not something somebody could actually, disability for work purpose. That means the person at the end of the day is an infirm who cannot provide, who will not be able to work and provide for themselves, and therefore the need to cater for them in.
Chair, the chair of the committee comes from northern Uganda, where there is this lethal drink called lera lera. Now, many young people who have fed themselves on lera lera for a while actually become disabled. Now, how would we deal with that case? Because now the inability comes in, but it's not due to medical. So how would you help parents in dealing with that, or the excuse, what is it, the administrator? How do you help in that situation?
But honorable members, I think that would be a question of fact established by medical examination. Yes. Mm. Hmm? Mm. Mm. Okay, on the members will remove the word unmarried or until they marry, wherever they occur. I now put the question that clause 55 be amended as proposed. Those in favor say aye, the contrary no. Let's have it.
Clause 55 as amended.
Questions clause 55 as amended do stand part of the bill. Those in favor say aye, the contrary no. Let's have it. New clause.
Chair, we're inserting a new clause immediately after clause 55. The new clause is amendment of third schedule to a principal act. The third schedule to principal act is amended by renumbering the schedule as schedule 4 and repealing form A. Amendment of fourth schedule to principal act. The fourth schedule of the principal act is amended by renumbering the schedule as schedule 5. Justification, consequential amendment arising from the insertion of a schedule on currency point to adopt the amendment contained in the 2019 bill.
On the members, I put the question that a new clause we introduced as proposed. Those in favor say aye, the contrary no. I have it.
Clause 56.
Honorable Chair, 56. New
Clause 6 is delete clause 56, justification, consequential amendment arising from the insertion of the schedule on currency points as schedule 1 instead as proposed in the bill.
On the members, I put the question that clause 56 be deleted. Those in favor say aye, the contrary no. I have it.
Then fifth schedule.
Members, I put the question that fifth schedule do stand part of the bill. Those in favor say aye, the contrary no. I have
That title.
Did we finish with the clause 1? Could you
Clause
finish the
1.
interpretation? Clause 1. Are there any changes on clause 1? Interpretation.
Clause 1, amendment of section 2. Clause 1 is amended, A, by substituting for paragraph A of the bill with the following: by repealing the word legitimate, illegitimate, and appearing in the paragraph B. B, in the definition of currency point, by substituting for the word fifth, the word first. C, in paragraph D, in the definition of daughter, by inserting the word first degree immediately before the word lineal. D, by inserting immediately after paragraph E, the following new paragraph, by inserting immediately after paragraph E, the following. GA, disability, as the meaning assigned to it under the Person with Disabilities Act. I think those are...
You had the interfered with the issue of the minor and the child.
Is there another E?
It's not in the interpretation.
Madam Speaker. Madam Speaker. Madam Chair.
Yes.
I reject the proposal C, paragraph C. D, the definition of daughter by inserting the word first degree. I reject that. This matter is addressed by the table of consanguinity was adopted in clause 11 of the Succession Amendment Bill. Alternatively, I propose to amend as follows: that paragraph D of the Succession Amendment Bill 2018 be amended by deleting the word a female child or first degree lineal descendant. The new provision will then read as follows: daughter includes a daughter adopted in a manner recognized under the laws of Uganda. On his proposal under E, he says in paragraph F, in the definition section, the word guardian by inserting immediately after the words customary guardian the following: testamentary guardian, statutory guardian, and a guardian by agreement of the parents of the child. We wish to reject this. The proposed amendment seeks to introduce the term a guardian by agreement of the parents of the child, but does not define the term. Whereas the definition of the terms customary guardian, testamentary guardian, and statutory guardian can be obtained from the Succession Act, the Children's Act, and Black's Law Dictionary. The definition of the term guardian by agreement of the parents of the child cannot be obtained from such established reference materials. The proposed definition cannot be interpreted, and attempts to apply it would bring confusion among the users. For example, what is the accepted agreement of the parents? Is it verbal, written, or recorded on social media? How does one apply this definition in the case of a child born of parents that do not live together? Our way forward, we propose to retain the definition in the Succession Amendment Bill 2018, which is similar to that in the Government Bill, the Succession Amendment Bill 2019, and the Children's Act. The definition of a guardian under the Children's Act is as follows. Guardian means a person having parental responsibility of a child. I beg to submit.
Honorable Chair. By the way, honorable members, a guardian does not just, you don't just sit there and say, I've appointed a guardian. There's a legal process. You have to go to court. Person has to be appointed formally and has to report the court, to account to the court. So this single agreement of the parents, I don't know.
Chair, my understanding is that there was harmonization which was done with the Land Attorney General and the private members. And that's how we came to the position that we have here. So I'm not sure whether this is a new development or.
But guardianship is a formality. You know, it's not just a question of looking after people. It's a formality under the law. You're appointed by the court or by we.
Madam Speaker, I understand we did harmonize, but some things were outstanding, and this is one of them.
Chair, we have consulted further and would like to concede with the discussion that we've had.
Okay. Anything else under the interpretation clause?
Mr. Chairman, since in the Succession Act, it defined a minor and we have maintained a minor. Instead of attainment of age of 21 now, we must amend this to 18 years. Because we have, Madam Chair, we have maintained a minor. So on the so we have to drop what the committee is proposing, and we maintain the but the amendment on shall be has not attained the age of 18 years. That's number one. Number two, Madam Chair, I have seen the committee had made a lot of interpretation, not a lot, but which are I've looked through it, but the chair have not mentioned it. like the one of principal residential property. He has not talked about it. Other residential properties, he has not mentioned it. And I believe that this would be important for purposes of this law because of the issue of marriage and issues of spouse and spouses, matrimonial home, yes.
Yeah, if I may continue to read the other, Chair, in E, which I think the Land Attorney General had already alluded to, in paragraph F, the definition of the word guardian by inserting immediately after the word customary guardian the following: testamentary guardian, statutory guardian, and guardian by agreement of the parents of the child. That's what initially the proposal was saying. F, by inserting a new paragraph immediately after paragraph F as follows: by substituting paragraph K, 2 with 2, married to the deceased in another country by marriage recognized as valid under the laws of Uganda. G, by deleting paragraph 1 of the bill. H, by deleting paragraph K. I, by deleting paragraph L. J, by deleting paragraph O. In paragraph P of the bill, in the definition of the word spouse, by inserting the word valid immediately after the word marriage appearing in the last line. I, in paragraph Q of the bill, in the definition of the word son, by inserting the word first degree immediately before the word lineal. M, by inserting the following new paragraphs in the bill as follows: I, by repealing paragraph I. 2, by repealing Roman numeral 2, by repealing paragraph N. Roman numeral 3, by repealing paragraph U. Roman numeral 4, by substituting paragraph W2 with 2 immediately married to the deceased in another country by marriage recognized as valid under the laws of Uganda. Justification: the use of the word child in the Succession Act is unique and separate from the way the same is defined under other laws. The word child under the Succession Act is used to define all the children of the deceased person, irrespective of age. Attaching age to the definition will mean that a person above 18 years cannot benefit from the estate of a deceased person, since this will be reserved for persons below 18 years of age. The definitions of word daughter and son are confusing the bill, since it uses the word lineal descendant, a term that includes all persons that share common stock or ancestor. The insertion of the word first degree ascending is intended to ensure that only the children of the deceased person can be referred to as daughter or son, and not extending it to other people such as grandchildren, as the bill had proposed. The deletion of paragraph 1 defining lineal descendant is for consistency, since the proposed definition conflicts with section 20 of the Principal Act. The deletion of paragraph O, the definition of separation, is for consistency with the amendment made to the section 30, making the proposed definition redundant. The proposal to delete the proposed definition of the words land or house from which the deceased person or surviving spouse was deriving his or her sustenance, other residential property, and the principal residential property are intended to protect customary land, as well as removing conflict between the definitions and amendment made to section 26 of the Principal Act. The definition are the unintended consequence of extending the residential holding beyond merely the homestead, merely by making section 26 of the Principal Act redundant. To consolidate the definition contained in the Succession Amendment Bill 2019 with those in the Succession Amendment Bill 2018. To remove redundant words which are no longer used, such as husband, illegitimate child, legal heir, senior wife, etc., as Senior Nandala may want to add. And finally, to remove the definition and any consequential inequality and any inequality based on gender. Thank you.
Madam Chair.
Yes,
We have only one rejection of L, paragraph L, which my colleague mentioned as I. It is paragraph L, which says in paragraph Q of the bill, in the definition of the word son, by inserting the word first degree immediately after the word lineal. Justification: the matter is addressed in the table of consanguinity adopted under Clause 2 of the Succession Amendment Bill 2018. The alternative we propose to amend as follows. Paragraph Q of the Succession Amendment Bill 2018 is amended by deleting the words a male child or first-degree lineal descendant. The new provision should read as follows. A son includes a son adopted in a manner recognized under the laws of Uganda. I beg to submit.
Chair, we are conceding the proposal by the Land Attorney General. Thank you.
Okay, honourable members, is that all? Are you through? But I still have a problem with the issue of the issue of the child.
Madam Chair, a child is a child, because even if a mother is available and even if you are 70, you will be a child to her. Yes, your mother will call you my child. She will never call you my big woman. No, you call you a child. Like my mother here calls me a kid. But for a minor, we must define a minor. And in the Succession Act, a minor is there. And we can only change the age as per the Constitution, but we cannot withdraw it. So my proposal that we amend the definition of a minor by only removing from 21 years to 18 years. And that also settles that, because in the amendments were made, we have referred to a minor, a person who has not attained the age of 18. So we should define a minor. And because it's already in our yes, Honorable Kakwaza, you come and supplement me. I'm not doing well.
My sister, my mother, I've been, you know why they created TVs in the offices is follow properly what is happening in the house. But Madam Chair, what I want to supplement to the Speaker, it will look a bit different. All the laws which at least we passed in this house, somebody who attained the age of 18 is an adult person, but a minor who is below 18 is the one we call as a minor. And all laws we have, you remember the age limit bill, we said those who attain the 18 years can contest because they are adult and they can start making their own decision. A minor is taken by practice that somebody who is not able to make his or her own decision and who is below 18 years. So for consistency, you cannot make another law different from others. I thought that in legislation, we should be consistent with other laws.
Yeah, honourable members, the issue of minor and major, under the law, the age of majority is 18. So if you are below 18, you are a minor. That is the option of the law. We can't change it. And for succession, you must differentiate between the young people and those who are able to take their own decisions. A child of 17 will not be able to administer an estate. He or she will require a guardian to be appointed by the court or by the will. So we should not change. Yes?
Just to clarify on Honorable Nandala's query. The Succession Act defines minor as being 21, but we have amended to bring it to 18. I think that is harmonious enough.
Is your brother down to 18? Okay.
Yes.
Then that's fine. Any other changes are under the Interpretation Act, interpretation section? Members, I put the question that the interpretation section be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 1 as amended.
With the question that was 1 as amended, do stand part of the bill. Those in favor say aye, the contrary no. Amen.
The title.
With the question that the title do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Motion for the House to resume.
Honorable Mover.
Right Honorable Speaker, I move that the House do resume and the committee of the whole House reports thereto. I beg to move.
Members, the question is that the House do resume and the committee of the whole House do report thereto. Those in favor say aye, the contrary no.
Report from the committee of the whole House.
Right Honorable Speaker, I beg to report that the committee of the whole House has considered the bill entitled the Succession Amendment Bill 2018 and has passed it as follows. Has passed it with the amendments and as follows. That's what I'm reading. I'm going to read the amendments. Clause 27 was passed as amended. Clause 28 passed without amendment. Clause 29 passed with amendment. Clause 30 passed with amendment. Clause 31 passed without amendment. Clause 32 was deleted. Clause 33 passed with amendment. Clause 34 was deleted. Clause 35 passed with amendment. Clause 36 passed with amendment. Clause 37 passed without amendment. Clause 38 passed with amendment. Clause 39 passed with amendment. Clause 50 passed with amendment. Clause 51 passed without amendment. Clause 52 passed with amendment. Clause 53 passed with amendment. Clause 54 passed without amendment. Clause 55 passed with amendment. Clause 56 passed without amendment. Then clause 1 passed with amendment. Right Honorable Speaker, there are also new insertions. Parliament made the new insertions and I read them. After clause 29, after clause 35, after clause 36, after clause 39, after clause 42, after clause 53, after clause 55. And they have been passed. Well, they have been passed
as part of the bill. Right Honorable Speaker, I beg to report.
Motion for adoption.
Motion for adoption of the report from the Committee of the Whole House.
Right Honorable Speaker, I beg to move that the report of the whole House be adopted. Right Honorable Speaker.
My members, the question is that the report of the Committee of the Whole House be adopted. Those in favor say aye, the contrary no. Let's have it.
Bill third reading.
Honorable Mover, third reading.
Right Honorable Speaker, honorable colleagues, I beg to move that the bill entitled the Succession Amendment Bill 2018 is read for the first time and is read for the third time and do pass.
Members, the question is that the bill entitled Succession Amendment Bill 2018 be read for the third time and do pass. Those in favor say aye, the contrary no. Ayes have it.
A bill for an act entitled the Succession Amendment Act 2018.
Members, title settled and bill passes. As the French say, finalement. It means finally.
Right, Honorable Speaker, honorable colleagues, I wish to thank everybody. I specifically wish to thank you, Madam Speaker, for your guidance and for your efficiency, Madam Speaker. For me, it has been like 4 years following up this, but with your guidance and with your efficiency, we have been able to pass this very sensitive and important piece of legislation. Thank you so much, Madam Speaker. Honorable colleagues, allow me to thank the people with whom I have worked with all these years. I would like to thank UOPA, and specifically our sister brothers with whom we have moved together. Thank you for your support. Thank you for being sober when we are handling a very, very, very sensitive piece of legislation. Thank you so much. I wish to thank government and the Attorney General and your team, the Administrator General and the team with whom towards the end we really had to sit together and harmonize. It was not easy. We all had our different opinions. We had made consultations here and there, but we reminded ourselves that we are legislating for Ugandans. We are not legislating for ourselves, but we are legislating for this country. Thank you so much for your technical guidance. Madam Speaker, I wish to thank the technical team in Parliament with whom I have worked with. Some of them are here, some are not here. But for their tireless efforts, Madam Speaker, I wish to thank you for putting together a team that is efficient. Even when I asked them so many times, I called them sometimes at time off schedule, they have always been there for me. John, Tamare, Susan, and rest, I really want to thank you, and thank you so much for the support that you have given us. I wish to thank also members of civil society that I've worked with, LandNet, UNET. Thank you so much for the support. Otherwise, the consultations across the country wouldn't have been as wide as we had them. So thank you so much. We don't take it for granted, the support that you have given me and also given me with the OPA. I wish to thank the seconders of this bill, Honorable Isaac Murindwa, who is here, Honorable Nora. Thank you so much for standing with me and for all your guidance. Thank you so much, everybody. Thank you, our senior legislators, Mama Cecilia, Honorable Mafari, and the rest, for all your guidance and for being here all the time to support legislation in this country. We thank you so much for your guidance, and we appreciate it. Madam Speaker, finally, I continue to thank you once again. You do us proud as women in this country for your efficiency. Thank you so much.
Thank you. Does the Attorney General want to say something?
Speaker, I want to appreciate the efforts which our colleague has put into this bill. But I want to emphasize that this is not a WAPA bill. This is not a women's bill. You have seen that what has come out of this bill, it benefits all. In fact, if anything, I feel that men suffer more when they are gone. They leave a lot of problems. I mean, they are already a problem, but when they go, they leave more problems. So I think what has happened is going to manage your affairs better, better than it would have been. But, Right Honorable Speaker, I want to request that the sexual offences bill be brought before we close. And I've been reliably informed that even the report is ready. So if we could tie sexual offences a bill with all these pieces of legislation that we have been pushing so much as the women in this house, I think that will make us proud as we exit the 10th parliament. So I would want to urge those who are dealing with sexual offences bill to ensure that the bill is dealt with before we close the 10th parliament. I thank you, Right Honorable Speaker.
For us, if you bring the matters, let me put on the other paper. Maybe Attorney General want to say something? Oh, the chair of the committee.
Madam Right Honorable Speaker, allow me to, on behalf of the Committee of Legal and Parliamentary Affairs, allow me to extend our gratitude to you for the guidance in processing this bill. Madam Speaker, this is a bill that was very contentious in the committee, and it is a bill that attracted, normally we don't lack quorum when it comes to this particular bill. I think because the members are very interested. It is a bill that also united the members across independence, position, among other things. And I think it has really united and energized this house. I see at this point in time, the ministers are in, my senior brother, Nadala Pafavi is not leaving his chair, Mama Cecilia, Chair, the Right Honorable Speaker, this is really a great, it's a monumental bill that I think will impact on our people. We want to really thank you. We want to thank the Land Attorney General for his insight. He made a lot of contributions. I remember at some point we had to go to harmonize our position. This has been a lot of work. I can't forget to thank the private member mover of the bill. It was our initiative. I know the Office of First Legislative Council, the Attorney General's office also came with another bill, but we were able to move together at the end of the day. And I think a precedent has been set. This is great for the people that we serve. I want to thank all the members that are really here. People, they have been sitting in whenever this bill is on the order paper. People sit in, they stay late, and it's normally the same faces. And I can't forget to thank particular members of our committee that have really taken interest. Honorable, my brother and classmate, Honorable Basari Wasuman. Madam Speaker, the Attorney General is also another, the three classmates. We are the biggest class in the legal committee, the Land Attorney General, Honorable Basari and myself. Madam Speaker, I can't forget to thank the technical team. The technical team have been instrumental. I think a lot has been said about that. We can't thank them enough. They've done us good. They've been very helpful. I mentioned Basariwa, Honorable Kamateka is here. Our senior mother, Grandma, Member of Legal and Parliamentary Affairs Committee, Honorable Veronica, and our substantive chair of the committee, Honorable both, who is in the trenches right now canvassing. Madam Chair, in absentia, we want to thank him. I can't say thank you enough, but I thank you so much, everyone who is here. I may not go and mention all the names that are here, but more importantly, you've been the pivot, you've been the driver, Madam Speaker, your guidance and wisdom, your contributions sitting in late to make sure these bills are passed in this parliament cannot go unmentioned. We really thank you for your dedication, commitment, and sacrifice, and we wish you the best in your endeavors. Thank you.
Thank you, Honorable Attorney General.
Madam Chair, thank you very much. And I want to thank the Attorney General and also my chair of the committee. Madam Chair, for me, Honorable Kajungu Mutambi has really demonstrated something. And I want to thank her so much. In fact, if I was a voter in Mbarara, I should have really fought for you. It's unfortunate I wasn't a voter. But Madam Speaker, this law, I think, was overdue. And I'm so grateful that this law has gone through. And I want to ask the Attorney General that you must make sure that this law is signed, this bill is signed into law as quick as possible. And I want also to tell Mama Cecilia that it's not only women who suffer. Women suffer more. Someone loses a wife, his sisters come, they want to grab all everything in the house, and these were my sisters, yet the law should protect the man with his wife's property. So even as men suffer. So Mama, don't say it's only women. But what I want to ask, that since Mama has talked about the sexual offenses bill, but also we need to talk about marriage and the divorce bill. It's a serious bill, and we need it urgent because we need to protect everybody. And I don't know why men are so scared. Eh? I don't know. I feel so surprised why a man should be scared. Why can't you allow your wife to sign a check with you? Why can't you? You see, yes. By the way, if you want peace in the home, let the door be open, let everything be known, you'll have peace. But when you hide things, you'll have insecurity in the house. If a woman takes money to build a house somewhere, she's not building for herself, she's building for your children. Because when she dies, or before she dies, she will hand it over to your kids. So, men, I would ask the Attorney General, let us fight this marriage and the divorce bill quickly and bring it and we pass it into what? Into law, because it will safeguard everybody. And Madam Speaker, I'm tired of seeing families fighting day in, day out. I am a chairman of a clan, and for me, I've passed already a decree that the moment a man has 3 children with a woman, that means that woman has nowhere to go, and it is you, the man, to go. And yes, because the first one could be a mistake, the second one could be another mistake, but the third one, how do you say that this man sleeps like this woman sleeps like, no. The moment you have 3 children, that means you must die with that woman or you must die with that man. So, Madam Speaker, I want to plead with you, if the Attorney General doesn't want to bring the law, I know my younger brother there, it's very good. I like him, Madam Speaker. I want to tell you that before NRM took him, that was our Attorney General, very intelligent young man. And for us, we're the training ground, then the NRM takes. So we train, but he's a very intelligent young man. But I would plead with him that, Madam Speaker, you work with him and maybe you call the president and say, but the problem is not the president because it has not reached his desk. So what we believe it is us, Parliament, to ensure that this passes into law. Madam Speaker, I want to thank Honorable Kajungu. I want to thank you so much. When you were moving this bill, I was so impressed seeing a younger lady, how he can move a bill to save the whole world. I'm so happy. And I wanted you to amend, if the speaker never stopped me, I wanted to amend section 222. It's a very dangerous section, but since you said we never went to the committee, but next time we shall do another amendment. Thank you very much. I want to thank all the House.
Okay, Attorney General.
Madam Speaker, I want to thank you for your stewardship, your unending commitment, your guidance that has brought us this far. And you saved us a lot when you asked us to harmonize, because the ping pong, the to and fro, the arguments, the interjections and whatnot, I don't think we would have finished this bill during this term, because it was a big bill with a lot of interests. But the fact that you asked us to harmonize, we were able to put our heads together. And I think it is one thing that we should do regularly, because I have seen some bills go. I wish to thank Honorable Rosette Mutambi Kajungu Christine, the woman MP for Mbarara district. I'm very proud of you as my big sister. If we were in another country, this bill would be called the Mutambi bill, because in other countries, private members' bills are named after them. You have left an indelible mark on the nation, because this bill will live long after you and many of us. Senior colleagues, all of you, members of cabinet, members of parliament, members of the legal and parliamentary committee, my mama Veronica, my big sister from Mitoma, Mama Cecilia, I don't know how I would have proceeded without you. Your presence gives us a stamp of approval because you are an elder. My big brother, Honorable Nandala, my brother Asuman, all colleagues in Parliament, thank you so much. Thank you.
Okay. Honourable members, I think I want to add my voice to commend the House for fulfilling your obligations under Article 79 of the Constitution, where required to make laws on any matter for the peace, order, development, and good governance of Uganda. I think in working together, comparing notes, harmonizing, we have been able to deliver a good law for the people of Uganda, and I look forward to its implementation. I really want to thank the members for the collaboration, the clerk and her team. This has been a very, very long journey, but we're happy to be here. And finally, concerning the marriage and divorce bill, on our members, it's like an albatross on this parliament. It's really like an albatross, and we really need to redeem ourselves. It's our responsibility to make these laws for the people, and it's only us that can do it. So I hope that sooner rather than later, the Attorney General, who is the owner of the bill, will come so that it can be completed. Concerning the sexual offences bill, I'm waiting for the report. So, members, thank you so much, clerk and your team. House adjourned to tomorrow at 2 p.m.